pardon to make a mention, my lord, one phrase writ appeal. In this case, I am appearing for Odisha University of Agriculture and Technology, my lord, wherein Honorable Single Judge is directed to regularize the service of respondent. In that case, contempt has been.
Regularization or service?
My lord, contempt
Already-
has been filed, my lord. And date has been fixed to 8.
So contempt is to be heard by the same bench.
Same, Honorable Single Judge, my lord.
So let it, what is the procedure here? Why don't they mention the matter?
And the order of Honorable Single Judge. Before 8, my lord, any date.
Lordships, indulgence, lordships. Here, my lord, is they have. Press it on the press.
By the collector, the action is going to assume the charges. I am the return candidate and I am not responsible for the collector as well as the
Participated in the process or what process? And then challenge the process.
Sure, I participated, I got selected, your lordship, my office has been well maintained. What was the order passed by this honorable procedure? And now the next purpose is going to assume the charges.
Pass on the memo, let us see.
Under your lordship.
With your-
The ground of urgency will.
Your lordship.
Test it will matter. Then kindly be listed because otherwise the department is going to take coercive action against the petitioner.
Lord, with your lordship's permission, may I mention a matter for early listing? This matter is supposed to come before the single judge, but I have some personal problem because I cannot appear before my Lord Justice A.K. Mahapatra. This is with challenging an order of the Human Rights Commission. The Human Rights Commission in an order has indicted the university and has directed the police to submit an investigation report. That order, which is an ex parte order without any notice to me, has said that the institute is guilty of abetment to suicide. And no, my lord, it's a single judge matter, but since I won't be able to appear because I'm requesting that the matter may be placed as a fresh matter. Oh, you give. My lord, there is a problem here. I'll tell your lordships. The UGC has been directed to take action against the institute without any notice.
It's not a order to be passed on a judicial side.
Yes, my
It
lord.
is the order to be passed on an administrative side by the Honorable Chief Justice. Because you wanted this matter to be assigned to any other single bench
Yes, my lord.
other than the bench which you have mentioned.
Yes, my lord.
That can be done on the administrative side. There is no.
My lord, I'm just praying that the matter may be listed on the 7th because I have a problem because
Pass on, why don't you?
Sir,
Please, we'll see.
I'll give the memo, but I would just pray that your lordship will list it either on the 7th or the 8th.
Yes, yes.
Very grateful, my lord. Very grateful.
Don't, done even today.
Very grateful. Very
Please
grateful.
pass on the.
Pardon to mention, your lordship, Madam, sir, relating to illegal encroachment of village road, your lordship.
Give the memo, mention.
I
in
don't
the
raise your
absence.
lordship.
Pass on the memo
I mean, this is a contempt matter because my lord.
of this bench.
Yes, my lord. Earlier your lordship granted the stay, so dismanagement order matter. But the contempt is not allowed to discharge the duty. It's only stayed by your lordship.
All right, give the memo, give the memo.
Honorable is not allowed.
It will be listed.
Let us see.
My lord, I may be pardoned to mention, my lord, item 13 and 16 covered matter, that is in absence of the GST tribunal, I have challenged the first appeal order.
Can't you wait till the matter is called?
My lord.
Just wait.
All right.
Let us see.
My lord, item number
Well,
31.
item 39, last but one item. I pray for adjournment. I have already taken consent from the other side. 39.
Adjournment for how many days?
Your Lordship, next week any day.
I may be pardoned, my
My
lord.
lord, item number 31.
May be pardon mentioned. Millard, I have already passed over the memo. This is a review petition, Millard, not assigned to this honorable bench. But my respectful submission that this matter may kindly be taken up by this honorable bench.
Two of the order passed by way. Whom?
Honorable Justice S.K. Sahu and Honorable Justice C.R. Das.
Both of them are available or not?
Available, Millard, this matter is not hard, but the order has passed that hard without your.
Whatever, madam, then you have to approve the same judge under order 47 rule 5.
Yes, I know, Millard, but I want
Go there.
one of the Justice S.K. Sahu be there with your lordship and this bench matter may.
No, you have not seen the assignment today, madam.
I have seen,
Today,
Millard.
yes.
I have seen.
Today, the Honorable Justice Sahu and Justice Das are sitting in the division bench.
I have
So
seen.
go there. So go there.
No,
Check.
Millard, I will satisfy your lordship in
Sorry?
when the matter will come before your lordship. Sufficient cause is there why this matter.
Madam, the difficulty in the law is that the review can be entertained by a judge who has passed the order.
Yes, Millard,
It
am I?
cannot be done by another judge.
No, Millard.
So when both the judges are available, then you can go and mention the matter before them. He
Millard,
can take up.
Millard, Justice S.K. Sahu may be there with your lordship and this bench because this matter has been.
And that was yesterday's roster. Now today the roster has changed.
No,
Now the
next
same
week.
bench is available. So you go and mention before the bench.
Millard, let this matter may be kindly be listed before your lordship and when this matter will.
We cannot
listed.
list, the review cannot be listed. It is against the procedure. It cannot be done. madam.
It will be
Sorry.
for ceremonial purpose. Order would be that release the matter, liberty to mention before the same bench. Do you want that order? We can
No,
pass
no.
the order.
No, Millard.
So better go. What is the difficulty?
My lord, item number 31.
My lord, may
Adjournment because Mr. Dola is on accommodation. Item number 31.
Other side,
In that item 31, I'm referring to the private respondent number 5. And there is an interim order by which I have been restrained from lifting the materials from the list.
so he's opposing the adjournment.
No, I'm not. He has called me and requested me, that I only pray that to 9th, next week, 9th, because he will be available on 9th.
9th.
9th,
Yes.
and I further pray to Thursday time,
9th.
9th, within serial number 10, because it is not reached for last two days, it is.
That can.
Why you underestimate the pace of
No,
a
no.
bench? It may be called immediately. Don't worry.
That it may be listed.
Don't worry. Even it is listed
No,
at 50, I will be taking up the matter. Don't worry. Yes.
Wait for an adjournment next week, madam. Item
Other
36.
side,
I'm for the petition, madam.
yes, what do you say?
One.
Yes, call the list.
I oppose it.
I want to make a mention, Miller.
Yes. Yes,
Miller, read of, fresh read of in 2323/24, Miller. The appeal was filed on 17/8/2024. Despite several online memos, the matter is not getting listed.
look at it, why it is not listed. Yes, we'll see to it, why it is not listed.
Pardon, my lord.
Obliged, Miller.
I may be pardoned, my lord.
Yes,
Item 37. My senior has some personal difficulty. I prefer to adjournment. my lord.
other side,
I have intimated, my lord. I have already intimated. my lord.
where are they? Just wait for a call.
Right.
If they come, don't worry.
Supplemental list fresh admission item number 1.
My lord. Here the appeal has been preferred against the judgment Honorable single judge and the prayer in the writ petition is at page 21 of the appeal. I am submitting prayer under the above stated facts and circumstances, the provisions of law, the appellant sincerely prays before the Honorable Court to be graciously pleased to set aside the impugned order dated 8th January 2025, Annexure 2, and direct the opposite party bank to release unpaid terminal dues such as 240 days privilege leave encashment and pension and oblige.
So that is a final relief to be granted in the appeal, sir.
My lord, I'm just, I'm bringing to notice the prayer of the appeal. Thereafter,
Now the disciplinary proceeding has culminated into an order of dismissal.
dismissal.
So now we have to hear out
My
the single bench has dismissed your writ
yes,
petition.
ma'am. That is why appeal has been preferred.
True. So have you served the copy of the memo or the application upon the other side?
No, as a fresh admission.
This is a fresh application. I issue the notice.
We issue the notice, then I will.
Yes, please, yes. Issue notice upon the respondents. What is the system here through court or?
Item number 2.
Hello, may I please, your lordship? Well, I have here, my lord, I have challenged the my lord, interim order of the honorable single judge. When the honorable single judge has not stayed the recruitment proceeding, I have challenged the recruitment proceeding through a service provider of the Sri Jagannath Temple Administration. When the division bench of this honorable court and the government has banned the my lord, the recruitment through service provider, this is the judgment of this honorable court by a division bench.
And there is also a government notification.
Yes, yes, my lord. There is a government notice. I have annexed that, my lord. There annexed, my lord. That is annexure 3, my lord.
It's my roommate Jay from the police department.
There are rules also, my lord. I am handing over the rules, my lord. There recruitment rule also says that it has to be done through advertisement by public advertisement. My lord.
See, there is already a page 90. You are for the government.
I'm for the government and
Yes.
equally appearing for the chief administrator. My learned AG is there, my lord, online.
Yes,
He has to address.
sir, there is already a government has already taken a conscious decision, the learned AG, not to employ any agencies or the person to do the maintenance work. If this is the mandate of the government, can the administration or the temple administration defy the order of the government?
My lord, this Jagannath Temple Administration, my lord, it is being, my lord, regulated as per Sri Jagannath Temple Act. It's a special statute. And there is a separate committee of management which has been constituted, led with the Gajapati of Puri as the chairman of the committee and a senior officer in the rank of commissioner cum secretary as the chief administrator. They have their own rules. Lord, this particular recruitment, it is not exactly a recruitment. It is, my lord, has been given to one outsourcing agency for deployment in the Jagannath Temple, my lord, JTP.
That I appreciate, learned Advocate General. There is no difficulty in this regard. But what troubles me is the notification of the government at page 19 of the writ petition.
Let government, first of all, my lord, let me raise some technical issue first regarding the maintainability of this writ appeal. I'll go to the merit little later. But this is basically an interlocutory order. Your Lordship knows the latest patent jurisdiction of Your Lordship in the writ appeal. So this is an interlocutory order. Lord, what is seeking essentially to direct in the interim to stall the
I do not
recruitment
know.
process.
I appreciate it because it is, I think, akin to clause 15 of the latest patent.
Absolutely, my lord. The same
1862.
thing. Right, my lord.
Whether
This
it
is-
comes within the purview of a judgment. You wanted to say whether it comes
Right,
purview of the judgment.
That's correct. Lord, the main bit-
Babulal Khimji's judgment, what you have to say about it of the Supreme Court?
No, my lord,
What would
basically,
constitute a judgment and what would not constitute a judgment?
Lord, basically the Writ court, this learned single judge is in session over the matter. So, my lord, we are yet to file a response. It is pending. My lord, Your Lordship may.
But the
there is-
interim order, if it is passed and it has got a large ramification, then will it not come under the purview of the judgment?
No, my lord, there is no ramification at all. This is for
Because he says that whatever is done will be subject to the final outcome.
That's correct, my lord. If he succeeds, then that is, my lord, this is a temporary arrangement made by the temple committee.
We appreciate it because
for
the
the smooth
maintenance.
management of the temple administration and for the devotees especially.
Absolutely,
dearth
Mr.
of-
Advocate General, there is no quarrel to this because we are very concerned about the management, the cleaning and all everything of the temple.
This is not cleaning, my
This
lord.
is.
This is
Right.
this JTP, my lord, the police.
No,
police-
that's correct.
My
Sir,
lord,
we
it
have
is-
seen, we have seen the notifications. The notifications talks about many things,
My lord.
outsourcing. So we do not know. Lot of works are required for the management and administration.
Absolutely.
For that,
For
the
giving they have allowed.
human force or a human resource is required.
Right, absolutely.
So, but in what, you can't forestall the entire process
My lord.
to such a situations. We are quite conscious. We are simply asking that whether if you have sanctioned the pause, then why not the recruitment drive be undertaken by?
That will do. It's a purely temporary arrangement because now car festival is offing. Lots of devotees, Your Lordship knows, they trans to temple milord during this Akshaya Tritiya. Lots of festivities are there. So there is dearth of manpower in the temple itself for maintenance of.
What is the tenure of those temporary?
These are all casual. It's for a to meet
Casual
the
means on a daily basis or
on a daily basis, my lord. It is
No,
on a daily basis for a temporary period. It's not a permanent recruitment. My lord, we have to follow the reservation rule, etc., etc. If we go for the regular recruitment, my lord, the temple has also many such restrictions. We can't employ on caste basis. Also, Your Lordship knows lots of sentimental and religious issues are involved.
That's true.
So,
That's true.
no,
But
that's correct. So therefore, my lord, it is purely a temporary arrangement. We have given it to an outsourcing agency for deployment of 75 or some odd personnel to meet the exigencies of workload for the time being. It's not a permanent recruitment. So therefore, my lord,
then what, have you diluted your own notification of 4/10/2005?
no, temple, my lord, has its own establishment, my lord. This temple.
And why you have
establishment-
issued this notification? Why the government has issued this notification?
My lord, that is to be
Is
seen in the
19
final merit. what is the applicability of that notification so far the temple administration is concerned? So that is being,
29 of the JT of the.
rule also says, the rule also, their temple rules also say that, have given this, given the, my lord,
Violative of.
my
Rule
lord,
20.
these, my lord, these outsourcing agencies, my lord, your lordship may kindly, even the Honorable High Court is also, my lord, engaging people on outsourcing basis. My lord, your lordship may, my lord, the Honorable High Court, my office, and the entire, my lord, government establishment of the state secretariat, they are all manned by those, through those outsourcing agencies. So in the group D post, my lord, there is no base level recruitment as of now. My lord, Justice ROUTRAY is also aware of it. In our own High Court also, my lord, your lordship have employed those outsourcing agents and they are, my lord, supplying manpower. So there is no question of any regular recruitment. In my office also around 50, 60 people are working through outsourcing agencies. So this is purely a casual and temporary arrangement, my lord, for smooth management of the temple. That would cause, my lord, lots of dislocation for the devotees, for the pilgrims, for lakhs and lakhs of people, those who are visiting the Lord Jagannath temple every day. It's not a regular recruitment, my lord. The procedure for regular recruitment has been contemplated under the rule. It is purely a temporary arrangement.
JTPs.
The same, my lord. This is the, this regulation is applicable for all, my lord. So that is for
Given that
regular
regulation, my lord,
recruitment.
I have given that regulation.
Lord, that is for regular recruitment. It doesn't apply to the casual.
29.
Yes, my lord.
But 29 talks about the LDC or a similar
My lord.
equivalent rank.
Yes.
Now this GTC.
This comes under this regulation, my lord. They follow this regulation.
What is the remuneration? Scale.
The JTP also comes under this regulation, my lord. There is no separate regulation for the JTP, my lord.
Separate provision for this GTP.
No, my lord.
If there is nothing.
My lord.
Then how you can bring it? Because this is relatable to only LDC or an equivalent post.
My lord, that is the equivalent post, my lord, because.
But you'll have to show
the-
that GTP is equivalent to LDC or.
But apart from that, my lord, that is the equivalent, and apart from that, my lord.
Where is the equivalent? Show us.
But the division bench of this honorable court, I have given the order. I have, Mala, I have given the. Mala, I have given the orders of this honorable court passed by a division bench, where, my lord, the division bench has upheld that, my lord, that, and has, your lordship may see that order, my lord. Following this notification, my lord.
This is the outsourcing of a cleaning work.
No. Your lordship, I am reading, my lord. Outsourcing of cleaning work was outsourced. They have agreed it will be outsourced, but no JTPs. The job of the JTP will be outsourced. It will be directly under the administration.
But if their appointments shall be subject to result of the writ petition, then
Yes.
how?
Are you prejudiced? Once the appointment is made, your lordship sees, my lord. The persons who I am an agreed person because I am not I cannot afford my job because it is done, my lord, as per the pick and choose method. It has not been advertised. Nobody who is desirous for apply for that, he cannot apply. It is the outsourcing agency who will choose the employees, my lord. That's correct. They will choose the employee and they will appoint.
That is the practice everywhere in the government,
My
in
lord.
the High Court, in my.
The government
Yes.
has dispensed with so far as the cleaning purpose is concerned.
My lord.
They are their own.
My lord.
Now the government is before us and
My
the
lord.
government has no
Objection.
reservation.
He is not appearing for the government, my lord. He is not speaking for the government. He is speaking for the temple administration.
No, I think the London Advocate
No,
General.
Advocate General is appearing for the temple administration.
Government.
No, he cannot, my lord. He cannot.
State is a party, what are you are-
He is
you are
appearing for
relying-
the my lord, temple administration.
Who's, Mr. Pal, you should mind your language. As the state is a party, I can't address the
State-
court, even if.
But
state
you
is
said
not
that
a
you are
party, I
appearing
have
for
a
the
right to
temple
address.
administration.
In public interest, you must,
represent the whole of
you
the
must-
state.
But
And when you take
temple, my lord,
responsibility-
Jagannath Temple Act,
If
there's
there is a
separate act for
conflict
it.
of interest, sir, Kandi, if there is a conflict of interest, then definitely the advocate
That's
general
correct.
can represent for any party.
My lord,
If there is
I-
no conflict of interest, then in that event, he can represent and he's I would
No,
say
what
he's
he submitted, that is what I am
conveying the
repeating.
decision of the
only.
government.
I am not much, what he said, my lord, he said that he is appearing for the temple administration. That is
No,
why
I have not.
I
Please
read that.
don't misquote me. I have not said so. Mr. Pal, you should be careful. in
Your associate said it
submissions.
here.
No, no, I have never
But
said
he's-
so.
What
I have
are you
never
telling?
said so.
What are
I
you submitting
said-
to the court? Let us not quarrel interest. It is not
Don't-
fair to submit. I can address even in any matter. You should be aware of the.
Duration would be till the, what? Duration will be of a shorter time.
It is a for a certain time. It's for a certain.
Let them make a statement for that, my lord.
We will recording the statement.
Because they said, my lord, two things they said. Two things
The
the
advocate
advocate
general
general
is a
said.
very responsible officer
My lord, two things,
of
my
the
lord.
court. If once he makes a submission,
My lord, I'm just, my lord, I'm just repeating what he said, my lord. He said, but it is for daily, it is on daily basis. It is not monthly basis. They only pay daily wages and it will be a certificate. Those things may be noted and the case may be targeted. I have nothing to say, my lord.
Let every appointment.
that they are the casual,
My lord, he made a statement that this will be on the daily basis.
whatever. If there is a consolidated amount, I do not know, depending
That
upon
is-
the number of the days, then what can be done? So it is
Let-
always subject to the result of the rate. You also do not want that there should not be any security of the temple, because where
No, no,
there is a
my lord, he always want, my lord. My
large
lord,
number
what,
of
my lord, what,
the devotees who are visiting the
my
temple.
lord,
and-
my submission is, my lord, that the service provider will take a commission. Why not the temple administration directly appointment them, my lord?
Service, they cannot
What I have understood, my lord, they will be paid 12,000 rupees to the service provider and the service provider will deduct 2,000 rupees and they will pay 10,000 rupees to the person. Why not the temple administrator directly appoint them, my lord, on contractual basis, my lord? What is the, my lord, why the service provider will be
Lord,
brought in?
this outsourcing engagement is also, my lord, is being followed
1
by the
minute, sir,
Honorable
1
High
minute.
Court itself. There is a service charge. It's not commission. It is a service charge of
Take care of your submission.
Man. And one more, prayer, my lord.
The
One
writ-
more,
the
one more
writ
prayer, my
appeal-
lord.
The writ
That-
appeal,
That writ application may be targeted.
writ appeal arises from an order dated 5/3/2025 passed by the single bench in WP within bracket C number 6481 of 2025. Whereby and whereunder an interim order to the effect that any appointment / engagement made in the meantime shall be subject to the final decision to be taken in the final decision of the writ petition. A preliminary objection is raised by the learned advocate general that the instant appeal is not maintainable, having filed against an interim order which does not come within the purview of the judgment. And visaged under clause 10 here.
Clause
Clause-
10.
Clause 10,
Let us-
chapter 8, sub-rule 2 of the Odisha High Court rules,
Right.
No, clause 10 of the
A
letter.
chapter, clause 10 of the latest.
referring to clause 10 of the letter patents.
You're writing.
My lord.
According to the counsel for the appellant, there was complete embargo having created by the government in outsourcing any services And even the rule which has a statutory flavor does not contemplate, does not rule, the regulation 29 does not contemplate outsourcing of the services. Stop. Apropos the opposite, the submissions having advanced before us, it is a specific stand of the state government, the London Advocate General, that in order to facilitate the effective, the management and the administration, the decision was taken to outsource the services of the Jagannath Temple Police by appointing the persons on a casual manner, on a casual basis, which is purely temporary in nature. He further submits that there is no impediment there is no impediment in this regard, as the outsourcing is not perennial in nature, and therefore the contention of the appellant does not appear, is not correct. We have been taken to order of the division bench pass in the writ petition within bracket C number 23838 of 2021 at 2011, where the stand of the government was duly recorded with regard to the dispensation of the restrictions which was imposed initially in outsourcing the cleaning operation for the engagement of the temporary sweepers. Though the JTP was not directly under consideration, yet certain observations have been made in the said order.
No, it was filed by the JTBs only, my lord. These writ applications were filed by the JTBs.
I do not know, because it has been dispensation. What I've said? Pertaining to the JTP, that since the government has not dispensed with and or relaxed the restrictions initially imposed, such outsourcing may not be permissible. The Learned Advocate General is very categorical in his submission and conveys the laudable intention of the government that such engagement is purely contractual in nature and does not create any inchoate right into the persons so engaged, and therefore such restrictions which was initially there does not appear to have been pressed in action at this juncture. Furthermore, since the single bench has clearly observed that any appointment and or engagement made pursuant to the said circular or notification, what is this?
This is
Or advertisement?
only a letter, my lord.
Pursuant to said,
Letter to the private agency. Section 1, my lord, page 17.
pursuant to the
Letter dated 27/2/2025.
Annexure 4.
Annex to,
Now, pursuant to the advertisement dated 27/2/2025 shall be
It's not
subject
an
to-
advertisement, Milord. That's a contract letter.
Yes, advertisement I have said, subject to the final outcome of the said writ petition. And therefore, we do not find any justification in interfering with the impugned order at this stage. The appeal and applications are accordingly disposed of. For abundant precaution, we hereby made clear that all points available to the parties are kept open. If taken before the single bench, shall be decided on its merit.
may I pray only one thing, my lord, the writ petition may be targeted so that, because
Can't be
No,
done.
no, sir.
Nothing.
That can be done by diplomatist.
Item number 3.
May I please, Your Lordship? So, ALL Lordship, so last question, Your Lordship. The direction was given to the State Council to take instruction. The perimeter order was passed on 12th March, Your Lordship.
But we have already filed a counter affidavit. I'm serving a copy on my learned friend. Let him go through.
Fine.
Though by an order dated 12/3/2025, the direction was passed upon the state council to obtain the written structure. The council for the states please leave to file the counter affidavit dealing with all the averments / allegations made in the instant writ petition. The copy of the said counter affidavit is handed over to the council for the appellant in court today.
My Lordship.
Want to file rejoinder?
Yes, Your Lordship. 7 days after, Lordship, I am.
On the prayer of the appellant, let rejoinder be filed within a week from date.
My Lordship.
Release the matter immediately thereafter. Give a date.
Obliged. Item number 4.
With the Lordship, the land of the government land have been encroached by the opposite part number 8 to 13, and by which the Go- Yes.
Somebody outsider
Yes.
is reminding you of
my lord,
the fact that your land is being encroached.
yes.
Your lordship may kindly
So
see,
keep your own land.
no, my lord, the eviction drive was initiated. Your lordship may kindly have a glance to annexure 4.
Yes.
Yes.
Annexure 4. This eviction drive was initiated and the sub-collector requested the superintendent of police Baleswar to provide
Adequate police force.
adequate police force.
Yes.
Then subsequently, when it came to the notice of the authorities, that is suit pertaining to the land is pending before the court of civil judge senior division Baleswar. Then the sub-collector directed the Tahsildar not to proceed with the eviction drive till the final.
Any interim order is
Yes.
passed in the suit?
Yes.
But
I'm just asking you whether any interim order is passed in the suit,
but
injunction or something like that.
regarding that, I'll have to obtain instruction, but
They take an instruction. If there is no injunction passed in the suit,
Yes.
then where is the
Yes.
difficulty on your part to
Yes, ma'am.
proceed and
my lord, there is
And-
another difficulty.
and-
for?
Another difficulty, my lord. In fact, although the sub-collector requested for police force for the eviction, but as the alleged encroachers are parties to the present writ petition, the encroachment proceeding as contemplated under the OPLE Act, Orissa Prevention of Land Encroachment Act, should have been initiated. But instead of that, they straightaway sought for police force to evict. So the rights of the parties are also to be looked into in terms of the provisions of the OPLE Act. So that is also another ground to defer
But who
the.
stops you
This is-
taking action as per law?
That is what
Yes.
Who stops you? Why you are taking that
Yes,
leap?
submission of the land.
If your land is
Council, I-
found
That is why-
enclosed,
but
It's very
that is why,
surprise.
that is why since the suit is pending,
Suit is pending, there is no interim order.
No injunction or
No
a
injunction.
which stands in a way of proceeding, then where is the difficulty?
but regarding injunction, I'll have to.
It
take
is very
instruction that is
crystal clear, they are
this,
supporting,
limited instruction
because this is
which I
the
have received.
submission of the
And-
landed council. My lord.
You are really sprinkling the fuel to
Yes,
already a
yes,
spark.
yes, fine.
So spark is already there against him.
Because we have come, we have,
Sir.
we are come to support the government.
Sorry. Please
No,
wait.
no,
Yes.
he's sprinkling fuel to make it devastating fire. Don't worry,
Yeah.
the fire is on. Sir.
My lord.
Sir, when you say there is already a act in place, so why don't you take an action again under that act? This is the law. You have to take the steps. Why you will not take steps? Please submit your instruction, whether there is any injunction passed in the civil suit.
Yes.
If there is no injunction passed in the civil suit, then you will have to take steps
Yes.
in accordance with law.
Next
Uh,
big man.
The dispute pertains to the illegal encroachment by the squatters over the government land. According to the council for the state,
My lord, that is one
according to the
basis of the
council for the
limited
state,
instruction which I
the
have received.
notice was issued on 18/12/2024 by the subdivisional magistrate Balasore for providing adequate police assistance to remove the encroachers from the government land. But they were apprised of the fact that such encroachers have moved the civil court. And the said civil suit is pending.
This is the instruction which I received
Uh,
yesterday.
The council for the state could not apprise the court as to whether any injunction and or interim order is passed in the said suit, for which the time is sought to take appropriate instructions. In view of the above, let this matter be listed after a week. When the state will inform the court as to whether any interim order / injunction is passed in the said suit, is standing in the way of taking appropriate steps in accordance with law.
Obliged.
Is anything more?
Yes, no.
You
my
have
lord,
been
obliged.
successful.
Obliged.
Item number 5.
Please. But in the year 2016, my lord, the government of Odisha, my lord, through its Department of School and Mass Education, decided to construct the Anganwadi Center building inside the premises of a primary school, my lord. Page 11 is that letter, my lord. If you lots.
They wanted the Anganwadi center. You have already identified a land. You
Yes,
have
Your
taken a policy decision to construct a Anganwadi center.
Yes, Your Lordship.
Do it. Why you are not doing?
Seek
This is your own decision.
Yes, Your Lordship, that the letter of the Tahsildar to the BDO also is the same, Your Lordship, that the land has been identified.
Yes, that's why we are saying that
Yes, Your
everything has been done. A policy decision is taken by you to construct a Anganwadi center. If you have taken a policy decision, then construct, that is their reward.
Lordship may pass on orders and all, or I'll seek instruction as to what is the present state, Your Lordship. Whether
Have you
they're in
already
need of
taken-
funds or I don't know.
Have you
Your
already
Lordship.
taken
Because this is
taken
the
a
letter
step?
dated 6
The-
1.
I think the plan has been sanctioned that what it should be,
Yes, Your
whether you have already invited the respective applications by floating a tender. All these things will have to.
I'll ascertain, Your Lordship. 2 weeks time. We'll give.
Yes.
So Ms. Patnaik, and GS6 time to get instruction in the matter regarding status of construction of the Anganwadi center asked for by the petitioner. List on certain. Yes.
2 weeks, 6 days. 2 weeks time, your
2
lordship.
weeks after you give it. Okay.
21st.
Item number 6.
Please, your lordship.
Item 6, where for the Union of India, they only send the copy of the mail. I need a hard copy because we didn't have a system of. So let them,
It's
my
fine,
learned
Lord.
friend, my local council may serve this
Give
day.
them a hard copy.
Lordship.
Both the
How soon?
cases, the connecting case also the same, I
How
think so.
soon?
During the course of the day, I'll serve you.
So in the meantime, we will issue notice that.
Yes, yes,
sending the
that's fine.
virus.
Yes,
Because the virus is challenged.
yes, yes, that's
Will
fine.
So
Yes, yes.
then we'll have to file a counter as well. You'll have to give a response.
My lord, my.
So how soon you can serve the copy?
During the course of the day, lordship.
Then we can list this matter in the next week for passing a direction.
Yes, ma'am. Yes,
We
ma'am.
will issue notice.
ASG will argue. Please tell us.
My lord,
You will argue or the ASG will argue?
I didn't understand, my lord.
I think you will argue or the additional solicitor general will argue. I do not know.
SG is appearing, I don't know actually. We don't have any SG, my lord. I am the DSG, the SG is not.
ASG.
No, no, my lord.
So,
Here, only this post is created, but it was not filled up. Recently, this post has been there.
So the solicitor general will argue
No, no, I will argue the matter here.
because this is of a greater importance because they are challenging certain.
Then I have not gone through it. I just could be, if I enter, they will.
So proposing is that we are directing him to serve the copy.
Yes, my lord.
in the course of this day.
My lord.
And then give a response by filing a affidavits.
Then it requires 3 weeks time.
We'll give
Yes.
you enough time.
Yes.
Don't worry.
Yes, ma'am. Yes.
Issue notice, Mr. Padil and DSGI accepts notice on behalf of the opposite parties. 4 extra copies of the writ petition shall be served on him in course of the day. Reply affidavit shall be filed within 3 weeks as undertaken by Mr. Paddy. List on up to 3 weeks.
My lord, here,
Petition
what I think is in any cases, I am taking assist of any of my CGC who will assist me to argue the matter. This
So
this
you have, today you have not taken any assistance. On the date of argument, you will take.
this argument, I am better than practice.
Lordship, there is a
Calcutta is
You
different.
mentioned the name. of-
Calcutta, there is the ASG, then to DSG, then others are there. Here only I am the litigation in charge, then senior
So
partner
the
counsel. and-
ASG and the two PSG.
Yes, yes.
And even an EESG. At circuit bench at Jalpaiguri.
Yes, yes.
Assistant additional solicitor general.
No, the DSG, now that post is a DSG, my lord.
Who is assisting you today?
Samantara.
Mr. GC Sam,
SS Samantara.
SS Samantha. Along with.
Calcutta is a big high court and there is a circuit bench, that's why government is paying.
Lordship, there is a connected matter.
Another
Same order for
connecting
both.
matter is there.
Same, sir.
Yes, yes.
Obliged.
Obliged. Serpent Mr. Ponda is there.
Item number, item number 7.
Learned senior Mr. Mant is out of station, so I pray for an adjournment.
Only my presence may kindly be recorded. My presence.
For very good reason.
Mr. Riva,
S.A. Mohanty.
Mr. Reshma Mahanti, Land Counsel for the petitioner, 6 and adjournment. For other side, you are Mr.
Bisma Anand Prusti.
List on after 1 week time.
1 week, my
Give it.
Recorded.
Obliged, madam.
grateful, my
There. Prepare.
No, his name is reflected there already.
grateful.
Lordship, I need some time, let it be next week, madam.
Why?
Madam, 8, madam. Let it be next week, some.
It's a very liberal way.
This is
Taking time. Anyhow. How much?
next week, madam. Next week,
Mr. What's your name?
BK Raj.
BK Raj, Land Counsel for the petitioner, 6 time. List on, give it date after 2 weeks.
Next.
Item 9.
May I please, your lordship?
May I please, your lordship? My lord's common order has been passed pursuant to a single show cause notice for multiple financial. Your lordship has already passed. Common order has been passed pursuant to a single show cause notice. Lordship has already passed an order. My lord's on 28th March 2025, department to file counter, your lordship. GST.
My lords,
It's a GST
yes, my lords.
demand.
Yes, my
Against order passed by.
No, you have said demand come show cause notice.
Yes, my lord, demand comes.
So they have asked you for a show cause. Have you submitted your show cause?
No, my lords, final order has been
Order has
passed.
been passed.
Order in
No, under
original.
annexure 1,
Yes.
the petitioner was asked to show cause along with the demand.
Yes.
So upon that, have you submitted the show cause?
Submit.
No, demand
as
comes
per
to
annexure
the one.
Annexure 2, final order has been passed.
So that order you are also challenging.
Yes.
So there is
But
no
this
need
is-
of challenging
it is-
annexure 1.
My lords, it is appealable order under GST
That-
Act. There is appeal provision is also there.
46.
For the tribunal.
Before the commissioner appeals. my lords.
Go there, when you're coming here, directly,
Everything should be taken care of there.
when you're coming directly. I can understand when there is no tribunal,
My lords.
which is constituted, then the High Court has given you an introduction for that.
Lordship,
But there is already a provision for an appeal, and the appellate authority is in place.
Yes, my lords.
Then why don't you exhaust remedy there?
my lords, similar order, your lordship's a bunch of cases,
Similar-
lords.
The similar order is of,
On similar order.
I do not know, when that was a case where, after the appellate order,
No, lords.
then
You go in appeal, statutory appeal is provision is there.
Yes.
Before that, one order has been passed. But still, I would submit that appeal authority is there to look after all this.
oh, this is a case of a multiple.
Multiple-
Yes, my lords, yes.
Oh,
My,
withdrawal.
yes,
And this is to be decided now.
as my lords, please.
How can you separately, all the assessment here?
In a
constitute
single
an
notice.
independent cause of action?
My lords,
Can you give a consolidated notice for all?
my lords. I'll file counter rules to that effect.
You have made the demand for multiple purposes. In one show cause. This matter-
My lords,
And tag them under along with this?
my lords. I'll file counter to that.
Please.
My lords.
List this matter along with WPC 8858 on 5th May as prayed by parties. Your name,
Chitrasen Parida.
C. Parida, and you are
My SK Roy Chaudhary, Senior Standing Counsel.
SK.
Roy Chaudhary, Senior Standing Counsel.
Item number 10.
Yeah, please, your lordship. Here, my lord, the petitioner is a licensee
in respect of a restaurant cum IMFL on-shop, my lord, since 2017 and 18, I would like to draw your lordship's attention to the.
Then the criminal has to come because you are assailing or challenging the white saw.
No, my lord. This is not virus. And item 10, my lord.
Oh, I can take.
10. Here, my
The
lord.
prayer which will was the impugned order of 17.3. Where is the
Yes,
order of
that is impugned order is at page, page 17, annexure 6. But my lord, during operation of the bar, there was a person came and purchased one strong beer and
10 rupees service.
yes,
service
only
charges while you are
towards.
taking.
My lord,
They are
that's why.
not permitted.
No, my lord, what I am saying, my lord, you may see, they have taken records of the policy. Policy says
Your invoice says 710.
10.
When it should be 700.
Yes.
10 you have said that is
Then-
service charges.
Yes.
Because you are providing a table, you are
Yes.
providing a chair, you are providing some.
Air condition, etc., water, etc., my lord.
Can you charge?
Yes,
That is
lord.
the question.
Why, if anybody charges, my lord, then there is a provisions for the imposition of penalty. Which,
Impose the penalty of 1 lakh.
no, that is statute says 50,000 is the maximum. Lordship may kindly see 50,000.
Deposit 50,000, they will be happy.
So, because that I have
What is the-
challenged,
what
my
is the
lord.
provision?
My lord,
Avoidable. Excise Act.
my lord,
Excise Act.
Which one?
my lord, rule 58. Rule 58, lordship may. That's rule type. Yes, my lord. Compounding offences. Subject to provision of section of any section 75, any person whose exclusive privilege, license or pass is liable to be cancelled under clause A, clause B or clause C of subsection 147 is suspected of committing an offence other than the sections of 58, 59, 57 shall be liable to compound the offence in lieu of cancellation of the payment of sum of rupees 5,000, which may extend to 50,000 rupees to be determined by the authorized officer. They have taken the recourse of rule 58. Then, my lord, the act
75.
75, that is the regarding compounding of offence.
Yes.
75 provides regarding compounding of an offence.
True. Whether it is a compoundable offence.
Yes, this is not offence, my lord. They have stated it is a irregularities. Offence is at section 52. They have categorized what are the offences. That apart, my lord, your lordship kindly see this section also.
So it is
provides-
an offence it is an offence other than say a rule.
Yes, rule notable. That's why I would like to draw your lordship attention on section
55, 58, 59 and
68. 68, section 68.
section 68.
8. Penalty for offences not otherwise punishable.
Hmm.
Any person who commits any act in contravention of any of the provisions of this act or any rule, notification or order issued or given under this act for which a penalty is not prescribed or else in the act
He
is
shall be liable to pay
to
fine.
extend to 50,000. So the maximum is 50,000.
So
We are-
sir, how can you go for 1 lakh? He have to pay 50,000.
That apart, my lord.
But he has to pay 50,000.
Yes, yes, yes.
So maximum, my lord. Section 64.
All right.
It further clarifies.
Mr. BP Das for the petitioner and Mr.
May I say one line only? Yes. One line only. Outer limit is 50,000. That is why the department has imposed 1 lakh, possibly something maybe
No.
there. If your lordship gives me.
That effect, my lord, if I would say, my lord,
I can take it.
without giving me any.
We appreciate, there's no difficulty, provided that any of the provision
Yes, I understand.
contemplates more than 50,000 rupees fine or the penalty to be imposed.
Yes, I
You
understand.
show us that it comes under this provision, we are happy. If the outer limit is 50,000,
That
how the authority,
That I submitted. Outer limit is 50,000. I found.
so
And Mr. B Das, London AGA for state opposite parties. The petitioner's limited case is that for violation of
Conditions of
and
license.
or
Conditions-
violations of
license.
conditions of the license and a penalty of rupees 1 lakh has been imposed upon him as per Section 68 read with Rule 58 of the Odisha Excise Act and rules. Stop. Next. According Section 68 of the Odisha Excise Act prescribes that whoever commits any act in contravention of any of the provisions of the excise of the said Odisha Excise Act or of any rule, notification or order made, issued or given under this act, for which a penalty is not prescribed elsewhere in the act, he shall be liable to fine which may extend to 50,000 rupees. Stop. Further, according to the provisions contained in Rule 58 of the Odisha Excise Rules, subject to provisions of Section 75 of the Odisha Excise Act, if any person whose exclusive privilege, license or pass is liable to be cancelled under clause small a, clause small b, or clause small c of subsection 1 of Section 47 of the Odisha Excise Act, each suspended for committing an offence other than sections 55, 58, 59 and 67, then he shall be at liberty to compound the offence in lieu of cancellation of license on payment of a sum of rupees 5,000, which may extend up to 50,000 rupees, to be determined by the authorized officer or the collector, as the case may be. Stop. Thus, a bare perusal of aforesaid provisions of the Odisha Excise Act and rules reveals that the authority is not empowered to impose penalty of rupees, penalty of more than rupees 50,000 in terms of Section 68. Stop. Here, considering the nature of violation as revealed from the impugned order under Annexure 6, we feel that the Superintendent of Excise, Jajpur, has exceeded his jurisdiction in imposing fine of rupees 1 lakh, where the alleged violation is admitted is the first occurrence. Therefore, we restrict the amount of fine to rupees 50,000 only and modify the impugned order to that effect. Next, with aforesaid observation and direction, the writ petition is disposed.
Obliged.
And one paragraph for this.
Yes, Mr. Das.
Yes.
The cumulative effect of the provisions as discussed here in above leaves no ambiguity in our mind that the authorities have to travel within the peripheral of the said provision and cannot transgress its outer limit. Once the statute provides the outer cap in relation to the imposition of a fine upon compounding the offenses, it have to travel within the circumference thereof and cannot impose the fine beyond the statutory amount indicated in the statutory provision. That's the only thing. Thank you.
Item 11. May I please your lordship. Now here, the petition has challenged the demand notice under Annexure 1 in an earlier writ petition at page 12, Annexure 2. And this Honorable Court has directed at paragraph 4 at page 13, to deposit 50% of the amount and the license will be released.
Short lifting of.
Yes, lordships have passed.
The minimum guarantee.
Yeah, lordships have passed on.
Your lordships have passed.
So do it.
Yes, ma'am. So that order.
And we are disposing of.
Come, Lord, it is to be paid.
It is to be paid, kept
Yes.
pending for your good benefit.
Lord, they have not renewed my license. 31st, they have closed
A
themselves.
copy.
The provisional license has to.
A copy of the earlier order has been provided to me, in which the matter has been directly listed on a separate date. It has not been disposed of.
Now it is listed on
10th, your lordship,
10th
it is
April.
there.
Oh, 10th.
You have gone through this
Yes,
changes?
I have supplied.
Just now, I received a copy of that.
No, no, have you gone through this
Yes,
changes?
yes, 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 ma'am.
You are ratifying it?
Very well.
You are approving it?
Yes.
This changes.
Yes, changes of date, in my case.
That is required.
Similar. order.
Same order, same date.
And there is another connected matter. But I have also
Which is
made
that?
modification of,
Which is that?
but WPC number is
Item 11, two matters are there.
8527.
That is also same order.
Same. I modified some
Yes.
dates and,
Connected matter.
Please show it.
yes, sir, absolutely.
Connected matter.
Item 12.
Item 12, maybe permitted to withdraw to file a better application, my lord.
You want to withdraw?
Yes, my lord.
Have you got an instruction from your client?
Yes, my lord.
Are you filing a memo to that effect?
My lord.
Yes.
Mr. What is your name?
P. Harichandan, my lord.
Mr. P. Harichandan, Land Counsel for the petitioner, seeks permission to withdraw the writ petition and files a memo to that effect. Accordingly, the writ petition is dismissed as written, granting liberty.
Yes, ma'am.
Sorry, first with liberty to file better application.
I'm
Dismissed,
appearing for the
is
opposite.
disposed of as written, granting liberty great for.
Lordship, I'm appearing for the opposite part.
What's your name?
Avinash Kedia.
Junior
Standing
Kedia.
Counsel.
Junior Standing Counsel, other side of it.
Item 13.
My lord, item 13 is covered by lord's order. This is regarding the first appeal order under the GST Act and the absence of the GST tribunal. This
Oh,
order,
yes. This is deposit.
yes, 10% I will deposit.
Deposit. You have deposited the entire tax.
Now I have deposited it.
Only the penalty and the interest component.
Only tax
Tax.
and interest.
then.
Then I have already deposited the pre-deposit at the time of filing of appeal. Now, in the absence.
He has deposited the admitted tax.
No, there is no admitted tax lordship. He is disputing the entire tax amount.
Yes.
So at the time of first appeal, he has disputed 10%. Now he has to
Deposit
deposit
Further.
further 10%.
Yes.
10%. Have you seen? Gone through?
Yes.
Same order.
Item 16, my lord, same.
Same.
16?
16.
16 also same.
Same.
Yes,
my lord.
16 also same.
16 also same.
Item 14.
Item number 14. Essentially will be requesting your lordship to pass a mirror order as it appearing at page 80 of the brief.
Page?
Page 80 of my brief.
80.
Where your lordship will find for the selection petitioner when the earlier sitting application was pending. But this honorable court protected the petitioner and disposed of, saying that till the application for sitting is considered, will be allowed to operate over the same place where it is operated. Now, Lord, my that application is rejected. After rejecting that application, they have suggested me to file a fresh application for another location.
Okay.
But that I have already complied. I only need that let them do it within a stipulated period and same protection which was granted earlier.
Who is for the other side?
State will be there.
It is on your request, they have identified another site.
Another.
Yes, Your Lordship, the previous site was not allowed because of public.
Objection. Now the another alternative site has been, they have identified and communicated to you. So you have to take a decision.
Take instructions, Your Lordship.
What instruction?
Instructions as to what has happened, Your Lordship, whether that site is conducive or not, what is the inquiry?
You'll have to communicate to him. If you say that it is not proper or conducive, or there are a lot of mass objections that are coming there, then you'll have to communicate to him.
Yes.
I'll seek instructions whether.
But you can't sit tight over the matter for all time to come.
That's right. And on my application, they have already conducted an inquiry and favorable report is already there on brief on page 87.
The alternative site which
Yes.
they suggested.
Yes.
So then why you are sitting tight?
Page 87 is the report.
Everything has been done.
Yes.
You have made an extensive inquiry. You must have made a publication inviting the objection from the every corner.
Take instructions as to what exactly.
Take instruction that come on Monday.
Monday, Your Lordship, let it come on Tuesday. One.
Come on Tuesday. It's a small matter, unnecessarily why you are.
Shop is lying closed. It's a highly generated, revenue generating shop. Prime location.
Mr. Rathar, learned senior counsel for the petitioner, Ms. Patnaik, learned AG. Ms. Patnaik, learned AG seeks time to get instruction within such period, least on Tuesday. As read by Ms. Patnaik.
Item 15.
But can I seek an interim relief now? Subject to your, of course, too short is the time they are asking for. My shop is running as on date. Let them not close it down.
They are going to close within 2 days.
Yes. They will immediately close.
The tenure has been, as far as my information goes, I think they have extended it to a month, Your Lordship.
No, they have.
30th of April, Your Lordship.
Oh, yes, last time there was, yes.
Not in 1 month. Let me correct my learned friend. That 1 month period, subsequently government has also again realized it and corrected it until further orders. There are 2 orders. I can show it.
So then why you are apprehending your closure?
No apprehension.
Extension of the license here, not in terms of the general order.
Your Lordship,
But because of this difficulty of rejection of a security application, they are going to close it down. That's the whole problem. Let them not close it at least.
So you also ensure that his shop is not
Yes.
closed till
It's not closed till
Tuesday.
Yes.
You come on Tuesday.
Right.
She has given an.
She will ensure.
Right.
she-
So grateful.
Item 15.
May I please, your lordship. My lord, this is again against an adjudication order under GST Act. For the year 1920, my lords, petitioner had avoided ITC, tax credit, my lords, complying all provisions of section 16(2). That's the only point on which the matter will be decided.
They have said that you have wrongly taken advantage of the input tax credit.
My lords, I'll take a lordship to 16(3), section 16. But that's the only issue, my lords. And for previous year, your lordship have already issued notice for 18-19 to examine this matter. This is the order of the law.
Where is that order? That was on a identical,
Absolutely identical only for another year.
only the assessment year is different.
No, same. Only year different.
Oh, that's why assessment year is different.
Only minutes. Only assessment year different. Or issue same, fact same, party same, everything same.
You agree, sir? It is same.
Did amako beta.
What is your good name?
Avinash Kedia, junior standing.
Okay. No, somebody else appeared. Somebody else appeared.
Senior standing counsel.
In fact, an order of the Calcutta High Court minutes on same point, allowing. Can you see this order minutes?
Justice Sivagnana?
Minutes. They went to Supreme Court and Supreme Court dismissed that. That is the reason court wanted to examine this matter here minutes. Para 4 and para 9.
This is what is
Now what happened to this writ petition?
pending.
This,
That stage minutes. Court wanted to hear it. Finally.
it is
So it is
pending.
Pending. That's why I say both the matters let come together. Lordship here on this sort.
So it is posted to which date?
Lordship it's indicated that.
No, it is 10th September 2000.
After that, it has not come.
After that.
They are not.
But in this issue, there are two issues. One issue which is been, and he has taken the ITC of a cancelled dealer. The dealer has already been cancelled on
In relation to a transaction ensued prior to cancellation or after cancellation?
That is after cancellation. That the ITC which is claiming of 7 lakh some order,
Okay.
which has been taken after the cancellation, the license of the Subhranshu Das as page number 6, which he has mentioned
Yes.
of the brief. The license has been cancelled on 28/2/2019 and the transaction is made in 1920. So in this case, he has to pay that amount.
How do a common businessman know that
Yeah,
the person
that
with
can
whom
be-
he is?
That can be seen on the portal itself. Lordship, the online portal is there and you can search a dealer and from that dealer you can get all the details. From that I have got this.
My lord,
Download
my
the
lord,
copy.
while we are dealing with an adjudication order, we cannot go beyond that. My friend should confine to adjudication order. Only ground have taken in adjudication order. The supplier has received money from me, taxes, but has not deposited.
Deposited. So
That's the only thing that please say adjudication order.
Where both the matters and
Yes, ma'am.
final call.
Let me decide this.
Sir, the difficulty is if your authority has taken a particular ground, can you improve that ground
Exactly. ma'am.
standing at the bar?
He has mentioned that is for a cancelled dealer.
No,
I'm asking you
Lordship.
No, he
that
has
you are
mentioned.
taking this plea that the registration was already cancelled of that particular dealer.
Yeah.
Your authority took that point while denying their right.
Lordship,
I can play.
2A, but the ITC has not been reflected.
No, I can place the adjudication order.
You file the return.
No,
I can
asking
place the
one thing.
adjudication
I will
order.
tell you why I'm asking
I know.
this. When your authority means the department disallowed their
Yeah.
ITC, saying that the dealer did not deposit that GST which he collected from him.
But I can place the
Can you
relevant
take a
portion.
plea, an additional plea here that dealer already suffered a cancellation of the certificate prior to the transaction? That is the first question. Because of the judgment of the Supreme Court in MS Gill judgment.
Yes.
In the MS Gill, the Supreme Court has said that you can't improve or take a ground which the authority did not take at the time of an adjudication. So that is what he's taking a plea, that you can't.
Page 35, para 5.4.
So anyhow, come ready and consider that judgment of MS Gill as well.
No, not only that, Lordship also consider this, even if he's a cancelled dealer.
And Mr.
If I saw record that I have paid the taxes.
Standing counsel. It is submitted at the bar that the issues are same as in WPC number 19342 of 2024. Stop. 2024, which is pending before this court. Next. List along with aforesaid writ petition on give a date after 2 weeks.
My application by interim order is late over.
That we are not saying anything.
3 weeks, your lordship.
3 weeks after give a date.
23rd.
Obliged.
Item number 17.
May I please, your lordship? Here also the petitioners are licensed in respect to restaurant on shop. They were prevented not to lift.
Now you have challenged the virus.
Virus. Now, more than 400 cases are pending where interim order has been allowed. And that matter has to come for final disposal. Well, this is your order.
400 matters.
400 cases.
Relating to this.
This particular policy, my lord.
The clause 3B of part D of the excise.
Yes, my lord.
For the year 24-25.
Yes, my lord.
Is the pleadings complete in any of those?
No, not yet. They have not
matters?
filed any counter. Today also I have so many cases done in item. just
Here,
up to this
after
matter.
availing the benefits under the policy, the petitioner at the fag end of expiry of the policy has come before
Perhaps
this.
my lord and government advocate don't know the policy has been extended for 1 month.
Your lordship may kindly have a glance.
If challenging the same clause, there are many other writ petitions are pending.
They have come before the date, the last date of expiry. Your
The policy has been extended up to May 2025.
You have to file your reply in all
Yes.
those cases.
Yes.
And you cannot say this case is
Only-
different from those.
My lord,
Take a lead case,
My lord.
file your affidavits,
yes,
and let this point of the virus be decided
yes, my lord.
before it receives a natural death.
My lord, today's item 34 is also pending before us.
You are saying that at the fang end, when this policy is going to expire, that's why I said, before it receives a natural death.
My lord,
How soon?
My lord, the policy expired on 31st March 2025 or till
already
the new.
expired.
no, my lord, my lord
The
has not
policy is framed.
He is not
That
trying
is
to understand.
annexed
The policy has been extended up to May 2025 by the government. Until further orders.
But that is not on record.
So
But
he
that is
says
not
if
on
it is an
record, my lord.
extension,
Extension.
then
my
it
lord.
is really, is
Extension.
still
That is
alive.
an extension.
So how soon you can file your affidavit? Any lead case, or this case may be a lead case.
But 2 weeks time may be granted. We
So
will allow six-
when they will file?
2
When
weeks?
not 2 weeks.
2 weeks.
You say a date, suggest a date, we'll fix it.
But
One
If
counter
I-
requires.
Any
my lord.
date after 2 weeks.
One counter
Any
is
date.
sufficient.
One counter would be
That
sufficient.
is what I say,
ma'am.
that let there be a one lead case.
Yes. Lead case is that reflects
Whatever,
that.
this may be a lead case.
Yes.
That you will get a privilege
Yes.
of argument.
My lord. But only in order, it has to be corrected the date of posting should lordship may fix it.
What? No, we'll fix. That's why we are.
And
So 5th of May,
my lord.
5th of
Mr. Das for the petitioner and Mr. Das for the petitioner also, S. Das, AGA. List this matter along with item 34.
34.
34.
Today's
And
case.
any other matter similar?
Yes, 34 we are there.
34. no?
34. It is batch of cases.
Along with the item 34, writ petition लिख दो and batch. On 5th May, as prayed by Mr. S. Das Land and AGA, who undertakes to file his reply affidavit within 2 weeks from today positively, and rejoinder, if any, shall be filed within 1 week thereafter. List on 5th May.
So I pray
This interim order is there.
Interim order there.
Interim order is there.
In this case, interim order not passed.
Same. What is the interim order?
To leave the 180 ml liquor.
The bottle of 180 ml till the next date.
Para 4 of the order I have given.
Same interim order.
Yes, sir. There are another case
Two
tagged
cases.
together, mother. Two cases are there. Obliged, ma'am.
Same interim order.
Subsequent 34 also interim order to continue till.
Interim order continues so that it can be disposed of
34 re kar dedo, interim order dated circumstances shall continue till such time.
till 5th March. 5th May.
Item number 18.
Briefly, the petitioner is aggrieved by the order passed by the collector at Annexure 1, page 12, madam. But the case is that
What are you doing? You are an off shop, you have a off shop license.
I am not doing it.
Off shop license and now using may not be as a on shop, but outside is on shop.
Look at the allegation, madam. Kindly see the
Allegation is
allegation.
outside the customers.
Outside the shop, I have no control. Anyone can go anywhere.
Yes. What is saying? If somebody buys and then goes on the road, then
That's
the police who has to take an action.
Exactly. That's what I'm trying.
But Annexure 1, your lordship may kindly. See.
One second. One more issue, Lord. I have not yet, Lord. I am raising the issue. Kindly see, Lord. Kindly see the
Hereby
second. One
informed.
second, Mr. Das. Kindly see.
You are saying functioning like an on shop.
Yes.
Anything was found within that particular.
Yes, that is one.
premises,
Two, you cannot confine me. You cannot ask me to shift it.
Public road.
No, within a particular area. Kindly see where from you derive jurisdiction, asking me to shift it within a particular ward when your policy itself says that it can be shifted anywhere in the municipal area. So you cannot confine me to that. One, two, you have no power to direct me to shift. Collector is not the authority to pass this order of shifting. It is only under Rule 53. Commissioner of Excise has the power, not the collector.
No, the major issue is that they have said that you are granted an off shop license,
Yes.
but in fact you are using it as an on shop.
No. Kindly.
So this is what their major grievance.
It says
And you can't convert the license.
I cannot. I am not also.
And the second issue is, the allegation is that the customers who are buying from your shop or buying this, they are really consuming it outside. your
Outside.
shop.
That is why that's
So these are the two grievances.
right.
So this has to be taken into consideration.
Correct.
First thing is, if their allegation is that you are using as an on shop, then there must be an inquiry report.
Exactly.
There must be some kind of a
Grateful, Lord.
inspection.
Grateful. Lord.
Anything has to be done.
Yes, absolutely.
There must
correct.
be some material
So grateful. Lord.
that would show that it is.
Yes, Lord. I fully agree.
And so far as the outside premises is concerned,
Right.
is the public premises on road, if somebody is there, how can you make him liable?
That instruction I'll obtain.
Provided he provides something.
That instruction
Inside.
I'll have to.
Inside.
No, even outside.
Mr. Rathal and senior counsel for the petitioner. The grievance of the petition and Mr. S. Das, land and AG. The grievance of the petitioner is regarding the instruction in the form of notice issued to him by the collector and district magistrate dated 18/3/2025 bracket annexure 1. It is contended on behalf of the petitioner that item 18. It is contended on behalf of the petitioner that all the allegations leveled against him, that it is operating as an on shop, is false and without any basis. Stop. Mr. Das, land and AJ, 6 time to get instruction. Stop. List on 5th May. Stop. In the meantime, however, we make it clear that if the petitioner is using his off shop as an on shop, violating the license, then the authorities are at liberty to proceed against him in accordance with law.
At this stage, your lordship cannot give that observation.
Against him. For that invites a consideration.
Yes.
So
Now they will find
I
it
think we
handled.
will take advantage of this.
You see that, however, only listen.
I'll humbly pray, Lord. Let them not take any coercive action till the obtainance.
That's why
I know. But let them not take any coercive.
The authorities are directed not to take any possible steps in the meantime.
Grateful.
Yes, sir.
The government's appeal, there is a limitation. I am the respondent.
Delay.
But my another one submission that the
How much delay? What is the
delay of 217 days.
Yes, 17 days. It's a government appeal.
government appeal. I am the respondent, the widow.
So what
Another
is there? What you have said about delay? Which IA is the delay?
The IA
So this was my order.
Oh, sorry, adjourn for a week. My brother has passed this order.
You should have pointed out, sir.
କହିବାକୁ ତ ମୁଁ ସେଇ କଥାରେ ଫାଷ୍ଟ କହୁଛି ଯେ my lord party order.
You ought to have pointed it out. Yes. Let this matter be listed after the.
No, next week, my lord, widow is not getting pension, my lord. Next week. And
You are sitting next week also.
oh, that, okay.
Why you don't understand?
Okay, my, okay.
Item 20.
20, my lord, identical matters were before this honorable court. This honorable court has already taken a decision that against FAO,
Yes, readable is not maintained.
read appeals are not maintainable.
So he has filed a IA for withdrawal.
No, no, I know.
Memo.
It's similar or
A
Sorry.
memo filed for withdrawal.
yes.
All right, Mr.
Balaram Behram.
B. Behral and counsel for the appellant filed some 6 permission to withdraw the appeal by filing a memo to that effect.
No, my lord. It's similar order, my
Could happen a memo filed by the appellant for withdrawal of the writ appeal?
lord.
Item
Against
20.
readable not maintainable. Similar case, my lord. Disposal.
Or you have filed the memo for withdrawal, then how you want the
That is all right.
Is
my lord.
not required.
Yes, my lord.
Item 22.
Dismissed as withdrawal.
Item number 21.
Same.
Withdrawal. Who is the appellant? So this should be Mahabharata.
The non-appears some call for the appellant, but a memo has been filed seeking withdrawal of the writ appeal. Accordingly, the writ appeal is dismissed as withdrawal.
Item 22.
22, possibly your lordship will not take up the matter because my lord
Oh.
justice.
Yes. Adjourn for a week.
Item 22.
Yes.
Oh,
We wanted to withdraw, but.
Item 23.
May I please your lord.
How much
Lord.
delay?
I think delay pointed out is the IA that we have filed.
Which IA? 1066 or 1067?
1066.
or dispensing.
Hmm.
Dispensing of filing of certified copy.
Certified, because we filed the review, that is why the delay has been pointed out at 201 days.
No, your IA number 1066 is for dispensing with filing of certified copy.
Maybe my noting is wrong there. 1067 is the delay.
So 1066 will allow, sir?
Dispensing is we have already.
It's a review. Since it's a writ appeal, 1066 dispensation allowed. And 1067 is how much delay?
201 days, including the days when the review application was pending, because it has been calculated from the day the writ petition was disposed of. The review application was disposed of on subsequently.
So after 92 days.
Yes.
So deducting 92 days, remaining is 101 day only.
The lordship condones. If the lordship condones, I don't have any objection, but it has to be calculated from the date initial.
Has to be calculated too, but
Yeah,
second
what
point
is
is
that?
that
You have challenged, you have filed a application. This is the application for appeal.
Appeal.
Against which order?
Against, my lord, the rule is has to be filed against the original writ petitions order.
I am asking you against which order you are.
Against both the writ petition order passed in the writ petition as well as in the review application.
The review was dismissed.
Dismissed, confirming the order passed in the writ petition.
Yes.
So if we calculate from that date, my lord, then the entire period would be 200. No, 8/1/2025 was the date on which the review application was dismissed, and the filing was 31.
This is the rejection of a application for review.
Yes.
This is an applicable order.
No, because that merges with the writ petition, because the,
Does it not?
because the same order is passed, confirming the order.
2000. You'll have to see that when the order of merger will come, and the principal judgment is the OJ Brothers case.
Yes, my lord.
So how can it be a merger review dismiss? Does not mean that the original order merges with the review order. Because the review is under these.
Very limited compass.
March. It will mark only through when a higher court is.
Yes.
But there is no appeal provided under all the 47 rules.
Against the review,
Rejection of the
review.
Allowing the review, definitely.
Yes.
Rejection does not. How can an appeal be made?
No, that is why, my lord, the original order of the writ petition is also has been challenged.
Now, two orders in one appeal.
In one appeal, my lord.
Now, okay.
So we can confine it to the writ petition itself also. It is on the subject to your lordships. Otherwise, I'll have to amend the application.
Say about the delay.
Delay, my lord. If a substantial question of law is involved, your lords may condone the delay. I don't have any objection there. But
Lord,
the punishment which was imposed was in 2011, but it was worked out in 2020 after 9 years, for which she missed the chance to be considered for the next promotion. And the ground,
one increment,
stoppage of one increment, and the ground they have given was inadvertently we could not implement, but the duty is casted on the petitioner herself, that she should have ensured that it should be implemented.
She was done the administrative officer. She
No,
could have
administrative officer of the SF Medical College, but reverse ones.
As a matter of fact, my lord, there was a case filed by the petitioner before the Central Administrative Tribunal for the purpose of getting promotion from OS to IS. This was the question. I was the Central Government Council then. So it was rejected there. Against that one, writ petition also possibly has been filed here. Right?
No.
When it was filed.
That was much prior to the.
After the imposition of the.
No.
Prior.
Her case was
Prior to
for
that.
promotion to the post of IS. During that period, that was located that the punishment imposed in the year 2011, having not been implemented, her case was not considered for promotion to the IS. That was around 4 or 5 years back.
The Learned Senior Counsel for the appellant and Mr. B. Das, Learned AG. It'll write this in IA number 1067. There is delay of 193 days, as pointed out by the stamp reporter, comma, in filing present appeal. Mr. Nandan and Senior Counsel, on behalf of the appellant, submits that the delay is mainly due to prosecuting the case in the review petition, which was disposed of on
8/1/2025.
Which was disposed of on 8 January 2025. According to him, if such period of pendency of the review petition is excluded from the count of limitation, comma, only 101 days will be there remaining towards delay in filing the appeal. The next one. Considering above facts as submitted on behalf of the appellant, as well as hearing both parties, and the reasons stated in the limitation petition, we are inclined to condone the delay in presenting the appeal. IA number such and such is disposed of. Then WA rate, list for admission on. That is also disposed of.
Any the next,
The applications are disposed of for admission into the peer.
yes,
For admission.
after 2-3 weeks, so that I'll be in a position.
For
to find-
fresh admission. For fresh admission. After 2 weeks, give a date.
Because he is to retire at the end of May, that's if my learned senior can.
Just
Yes,
starting,
of April, so if. I'll try my level best to. Yes, no further delay is made, that is my only request, my lord.
Yes.
Item number 24.
After lunch.
After lunch.
No after lunch.
Donation delay is there. You are not in the matter.
He is seeking after lunch, Passover, till lunch. How many days delay? Only 27 days delay.
Yes.
That. Mr. Das, we are condoning the delay. It is only 27
Yes,
days.
yes.
Hard Miss
Nadako, Mamta Behra.
M. Behra on behalf of Mr. S. Das, Learning Counsel for the appellant, and Mr. B. Das, Learned AGA. Upon hearing both parties and considering the grounds stated in the limitation petition, we are inclined to condone the delay. IA number 1068 is disposed of. Then writ appeal, list for fresh admission on such and such.
2 weeks, 2 weeks or 3 weeks after.
For admission, item 25.
Item 25, my lord. So far as the first case is concerned, this may be taken up in another bench as because my lord Justice ROUTRAY is concerned in this case. My lord. My lord, the first case, only the first case.
All the 3 cases.
Adjourned for a week.
My lord.
Joining it for a week.
My lord.
Item 26.
In item 25, there are some other matters, but that is it.
All are to be taken up together, sir. So, my
Different,
brother,
but-
one of the matter is there.
Sorry, but that's-
Segregation would really invite.
And then there are all different matters, altogether different.
So after 1 week,
1 week.
Item number 26.
Here I'm challenging the English order at annex 2 page 43 that ex parte order has been passed and it is here they stated the outside court settlement, refund of court fee.
maintainable?
My lordship, arising out of a suit, the collector Balangir has filed the writ petition, my lord.
No, the single judge order,
Yes,
the honorable single judge order is under Article 227, na?
yes.
So how the writ
But,
appeal is maintainable?
my submission of the writ petition is not at all maintainable, my lord. Arising out of a suit.
How the?
That CMP may be filed, but not the suit. And he is not a party to the suit.
Order passed in a suit
Yes, my lord.
is amenable to be challenged under Article 227 of the Constitution of India.
Yes, that's here, my lord, the
And
CMP.
Now, if they have,
Yes,
I
ma'am.
think it is a composite application saying application under Article 226 or 227 or 227 of the Constitution. But really it is under Article 227.
Yes.
If the adjudication is made by a single judge, whether the
And that's
whether it lies, I think under the latest patent, whether it lies.
Yes, my lord. My submission, my lord, since the case has been filed, that's a, instead of a writ petition, that the CMP should have been filed. But the collector Balangir is not a party to the suit. He has filed the suit.
Now,
Since the root is not maintainable.
the classification of a case,
Yes, my lord.
does it have any impact? I'm saying it's instead of CMP, it is registered as WP, but the two things there, whether the judge who has passed the order has the determination on the roster who came into him to decide those for.
No, that the writ petition should not have been filed, the arising out of a suit.
You are not
And
getting the
collector
point,
Balangir
Mr.
is not
Naik,
a
you are
party
not
to
getting
the-
the point.
Classification which is done, that's all. Does it really affect the decision on merit? I'm simply asking you.
Since my,
Except
sir,
that
writ
you
is not
have
maintainable.
The roster assigned to him.
No, my lord, sir,
Something
writ
of
is
that
not
kind.
maintainable. My submission was writ is not maintainable. The expert order has been passed. I pray, my lord, matter may be remanded to the Lord single judge to pass the
why
order.
No, why?
Single by bench and recalling an order and flagging all these issues. Why the appellate court will enter into this? First, ex parte order, you know your rights are there against an ex parte order.
Remanded, Lord. I pray for remand.
Why you will make a remand? Supposing ex parte decree is passed or ex parte order is passed.
Yes,
What is the remedy to the other side?
Since I am here for some time, my lordship may remand the matter. It
Why
will be,
remand?
purpose will be solved.
Then we have to satisfy the ingredients of order 41 rule 23. You have to satisfy the ingredients. We are asking that remand will not do, then we'll have to assign the reason. What is the reason? Ex parte order is the reason for remand.
Withdrawal.
Difficult, sir.
Okay.
Difficult proposition.
What do you say, Mr. Naik, Mr. Das?
There is already a full court judgment of this
Hmm.
honorable court, case of Mohammed South versus Dr. Major Sheikh Mahfuz, 2008 SCC online Orissa 46, which has subsequently been confirmed by the Honorable Apex Court in 2010-13 SCC on the point that writ appeals, letter patent appeals are not maintainable.
Has to be.
I'll supply that judge. And that judgment has been taken note of in another full court judgment. Has been again taken note of in another full bench decision of Loknath of Labba Kumar Ratha, which I have handed over now. Para 3 of that judgment, Your Lordship.
Withdraw, my lord, and the liberty may be given to.
Now liberty after 2 years will not grant.
Delay has been condoned. Here the delay has been condoned, and since I am here sometimes.
of the letters patent is very clear.
I permitted to withdraw and liberty may be given to approach the single judge court. Since I am here for some time. Sir.
It has to be dismissed. It will be dismissed, sir.
I'm also-
No liberty. After 2 years, we will not grant liberty.
No, the delay has been condoned
No,
since I am here
sorry.
for in the writ appeal for some time. And
Which
This
is,
is not a technical ground, but to consider, not a merit. It won't be the appeal is wrong, but that's the only.
and that's what I came out for withdrawal of the same and liberty may be given to approach the law single judge. Because the Honorable Appeals Court judgment is very clear on this point. That's the so far as the merit is concerned.
Yes. The judgment and order dated 14 December 2022 passed by the single bench, exercising the power of superintendence enshrined under Article 227 of the Constitution of India. The seminal point involved in the instant appeal relates to its maintainability in view of an embargo created under clause 10 of the latest patent of this High Court. The aforesaid provision is reproduced as under, and quote this 10. It is manifest from the bare reading of the aforesaid provision that the appeal under clause 10 of the said latest patent is incompetent against an order passed by the High Court exercising the power of superintendence under Article 227 of the Constitution of India. However, because of the divergent views having taken in this regard, the said issue was referred to a special bench in Lavakumar Roth versus State of Orissa, within bracket WA number 2047 of 2024. And answered in the following quote paragraph 33 of the judgment. More particularly Roman 3.
Roman 3 and para 22 also we taken note of, where they have referred to another full bench decision of this honorable court.
Anyhow, we are not going to make it a more lengthy order or a judgment. That will create a problem to it. In view of the authoritative pronouncement by the special bench in the above noted decision, the instant appeal is not maintainable. The same is dismissed as such. However, the dismissal of the appeal on technical grounds shall not prevent the appellant to exhaust the remedy if available in law.
Item 27.
Exhaust the other remedy if available. Paragraph 33, rule 3. This Roman 3 says.
I had an item number 27. The counter from OP 2, 8 and 9. I am for the petitioner, my lord. Just now I got the counter from.
So you want a file rejoinder?
Yes, my lord. 1 week time may be given.
Mr.
P. Harichandan.
P. Harichandan and counsel for the petitioner 6 time to file rescinder to the counter affidavit filed on behalf of the opposite parties.
No, I'm appearing for the opposite party number 4 to 7 on behalf of Mr.
On
Satpathy.
behalf of opposite party number 4 to
7 or so.
4 to 7.
I am for.
You have not filed your counter.
We have filed a count.
They have already filed their counter and we have already filed rejoinder.
Or rejoinder, that is there. Now,
Today I have received from my
now
lawyer.
this time only 1 and 2.
Yes,
2, 8 and 9.
2, 8 and 9. Okay.
On behalf of OP number 2, 8 and 3.
9.
2, 8, 3 and 9.
2, 8 and 9.
2, 8 and 9. Time is allowed. List on such and such.
But there is an interim order.
Interim order dated such and such shall continue till such and such.
Grateful, ma'am.
Item 28.
May it please you, Lord. Thus, the Odisha Public Service Commission has filed this present writ appeal. An advertisement was issued for the post of dental surgeons. The advertisement was at Annexure 1. There were 126 posts advertised for the unreserved category. 5 posts were kept reserved as a result of some litigations before this honorable court. Therefore, 121 posts were available for recruitment. Recruitment was to be made on the basis of a written test of MCQ type, multiple choice questions type, 200 marks examination. In the examination,
With any negative mark.
yes, ma'am, there is negative marking also. The results were published and 121 candidates were recommended. Thereafter, there were certain representations received by the Odisha Public Service Commission that the answer key that was published by the OPSC was wrong.
Of a particular question.
There are almost 15 questions, ma'am.
15 questions.
And there were certain writ petitions also filed before this honorable court, which directed the Public Service Commission to consider the representations. Those representations, once they were considered by the Public Service Commission, it was found that nearly 15 questions were wrong.
Questions were wrong or the answer?
The answers were wrong, ma'am. The answer keys that had been published, 15 answers were wrong.
That the questions were ambiguous. Then in that event, I can understand, or the questions were very clear, but the answers were wrong.
Well, it is
as per the answer keys.
Well, it is a mixture of both.
No, I beg pardon. It is found 15 questions answer has been wrongly mentioned in the key answer.
Okay. So it's not that the questions there is
Questions
any
were not wrong.
ambiguity in the question.
Questions were right.
Correct.
But by the order of this honorable court, the OPSC had not recommended the matter.
Written, yes. Then,
Well, it's
then
after that, well, it's the initial cutoff, the last selected candidate.
Then after these 15 questions, the answers given in the answer key was found to be wrong.
Yes, ma'am.
Then what decision was taken?
Then, my lords, the Public Service Commission prepared a revised select list. So, my lords, there is a first select list and there is a second select list. The first select list is on the basis of the wrong answer key. Those persons have already been given appointment. And there, the last selected candidate secured 189.558 marks. The respondent number 1, he had not cleared the cutoff as per the old select list. Now, in the revised select list, my lords,
yes,
the cutoff mark changed to 192. The respondent number 1 again fell short.
How much?
By, my lords, the cutoff marks became 192.558.
Yes.
And the petitioner and the respondent secured 192.210. Marginally. Well, the controversy arose. The point that has now arisen is, as per the revised select list, the respondent has not secured the cutoff marks. However, there are people in that select list who have been granted appointment who have secured lower marks than him. The learned single judge holds that the Odisha Public Service Commission did not have any jurisdiction to alter the cutoff marks. That is the error in law, because the learned single judge does not distinguish between a minimum qualifying mark and a cutoff mark. A minimum qualifying mark is something
is a barrier below which
I am grateful to you.
Cannot be said to be an qualified.
I am grateful to you, Lord.
And cutoff marks is only for the purpose of the filling up of the post.
Yes, my lord. The last selected candidate. Now, when the
Of
answer
the declared vacancy will be considered as the cutoff.
Yes, my lord. When the answer key was revised, then the marks secured by all the candidates changed. And therefore, the cutoff marks also changed. The learned single judge erred by holding that the cutoff marks could not have been changed. Post of dental surgeon.
The fill up on the post.
Well, on the last occasion,
Vacancy still exists.
as the state was directed to file an affidavit as on the present date whether there are any vacancies left.
No, we have filed an affidavit in terms of the order passed by this honorable court. Already you have filed that. Sorry, ma'am.
Two posts has been
Is
kept.
there any
Vacancy has-
or a future vacancy to come?
Future vacancy may come, but right now there are no vacancies.
No vacancy.
Right
They
now,
have filed affidavit, there are two vacancies, but the facts has
No,
not been
they are
properly
there.
stated.
there were.
The facts has not been properly stated.
Hmm?
My lord, first the advertisement was made in respect of 198 posts. Out of that, 126 is reserved for, which is meant for unreserved. After the written test was over, they published 198 candidates, 193 candidates. The names of 193 candidates, including the petitioners, were called for verification. of the-
Petitioners means respondents.
Respondents, sorry.
Unreserved category,
Unreserved category.
you said out of 198, 126 were the unreserved category.
Unreserved category. From the unreserved category, they took about 120 numbers. Out of 120, 5 did not join.
Yes,
It became 115.
So 11 posts remain vacant.
11 posts remain vacant. At that point of time, the petitioners approached this honorable court, but that there are 15 questions answered are wrong. They made a representation to the OPSC. OPSC has appointed an expert committee, and expert committee has already submitted a report. But the OPSC is not undertaking that report, not working out upon that report. Therefore,
Said that it worked on
My-
the report and that revised the entire marks.
no, my
No,
lord.
that there are.
Here, the honorable single judge, there are two writ petitions. The
Two
honorable
petitioners or more than two. Two petitioners in total.
two writ, one,
No,
the
yes.
respondent number 1 has filed two writ petition before this honorable court.
So only
What-
one candidate is there.
Two candidates, sir.
That's why I'm asking.
Two candidates. The first writ petition was disposed of by Honorable Justice K.R. Mahapatra, directing the OPSC that you examine the candidature of 6 applicants. 6 petitioners were different petitioners, were filed 6 writ petitions. You work out evaluate the answer script of those 6 candidates in terms of the expert committee report. They examined it and communicated to us that after examination, we found there is no change in the path. I will take your lordship to
No,
that.
you come to
Change
part.
in the-
No change in the mark.
Map.
These 6 candidates do not qualify. They intimated to us individually. Thereafter, we filed a contempt petition before this honorable court. Then, without following that expert committee report, they are now simply technically they have forwarded that all the candidates are found not eligible. They are not qualifying the above the cutoff mark. Then this honorable court in a contempt petition directed the OPSC, you examine again and inform the petitioners. Then they examine again and intimated out of 6, one has qualified, the other 5 has not qualified. Previously, on the very same expert committee report, they informed nobody above the cutoff mark. Subsequently, they say only one has qualified, other 5 have not qualified. Against that, 2 candidates preferred a writ petition before this honorable court. This
You are one of them.
I am one among them. 2 cases have been listed today. The W number 1328, the other one is
Connected to it. It is connected. to it.
30. In the writ petition, the challenge was to the OPSC communication, where they have stated specifically the cutoff mark is 189.558. The petitioner 558. The petitioner secured less than the cutoff mark. Therefore, their candidature has been cancelled. Again, after filing the content petition, they re-evaluated under Annexure 8, page 108, the very same thing. The cutoff mark has not been changed. Cutoff mark is 189.558. The petitioners cannot qualify. This is the improved order which was challenged before the Honorable Single Judge.
No, that is not that. This is the change of cutoff mark.
My lord.
It was the subject matter of dispute before the single judge. The change of cutoff mark.
But the Honorable Single Judge.
So what is observed in at para 48?
That
the decision of the expert committee to revise the cutoff mark. So the cutoff mark has been changed.
My lord. Before that, I will take your lordship to paragraph 45. 45 of the judgment by the Honorable Single Judge. On a careful consideration, page 206.
206.
206. On a careful consideration of the cutoff marks fixed for the written examination, this court observed that initially the cutoff mark
for your male
category was fixed 189.558. However, the same was revised subsequently on the advice of the expert committee, and the same was refixed at 192.558.
Page 206, my lords.
Page 206, internal page 34. Shall I read, ma'am? On a careful consideration of the cutoff mark fixed for the written examination, this court observed that initially the cutoff mark URM category was fixed at 189.558. However, the same was revised subsequently on the advice of the expert committee, and the same was refixed at 592.558. Since the petitioner had secured 192.002 marks after re-evaluation, and the same was found to be below revised cutoff mark, that is 192.558. The name of the petitioner has not been recommended by OPSC to the government for such appointment. However, this court is indeed perplexed to observe as to how the OPSC could recommend the name of Dr. Sripada Das, who has secured 187.934, Dr. Devashish Sahu, 188.108. No satisfactory explanation is coming forth from the OPSC.
Suppose the observation that even if it is taken,
my lord,
that the cutoff mark was 189.558.
My lord,
then how these candidates who also did not, I mean, achieve that 189, were recommended below.
Yes.
Below the cutoff marks.
Below the cutoff marks, they have OPSC has recommended some candidates.
That is what-
They-
yes.
Therefore, the honorable single judge has asked them the
Then
question. Next question.
No.
On a query being put to learned senior counsel appearing for the OPSC by this court, the learned senior counsel appearing for the OPSC submitted that cutoff mark has been revised on the basis of suggestion given by the expert committee set up by the OPSC. No further explanation is coming forth from the side of the OPSC to justify the revision of the cutoff mark. After conclusion of the entire recruitment process in the aforesaid background, this court is of the considered view that the OPSC should not have revised the cutoff mark 189.558 to 192.558. Further, this court feels that the OPSC, after re-evaluation of the petitioners and similarly placed other persons, answer script should have been applied the revised cutoff mark fixed earlier, and on such basis, the case of the petitioner and similar other person should have been assessed. This is more so in view of well-settled position of law that the rule of game cannot be changed when the game is on. In the present case, the rule of the game were certainly changed after the game is over. In such view of the matter, this court has no other option than to hold that the revision of the cutoff mark is illegal, arbitrary, and the same is unsustainable in law. And my lord,
This portion is slightly justified because there cannot be any rigid rule that they cannot vary the cutoff marks. Because if there was a revision of the entire, the OMR, it is based on the OMR.
Yes, my lord.
It's a multiple choice.
Yes, my lord.
So if there was certain questions where the answers were found to be wrong, somebody may have opted for option C, which was wrong, and option B was considered to be the correct. Then there would be a
that
reason
my lord,
for-
that is a development only in the counter affidavit. My lord,
Another
this,
issue which we have taken a serious note of,
my lord,
that even if the initial cutoff marks was found to be 189 point something, how these two candidates who secured lesser would be recommended? How? From your own stand, how can they be recommended? Are you not discriminating them?
What is your explanation to that effect?
But on those two candidates, there is nothing on record. My lord,
Have you taken any steps against them for their removal?
no, my lord, we have not.
If you have found that there has been some illegality perceived subsequently, are you not within your bounds to take the action against them?
But there is nothing on record giving any explanation. If your lordship requires, my lord, I'll take an instruction on what are the status of these two
When you
candidates.
say that this is a cutoff mark 189 point such and
Yes, my lord.
and the record says that you have recommended two candidates who secured 188 below the 189, then what's your explanation? And the judge said, no satisfactory
No explanation.
explanation has come from you. How can you do it?
So what is your presently, what is your explanation to that finding of this court?
Well, it's that I don't have any instructions on that point.
That is that is.
my lord, the other point is, fixation of a cutoff mark. It always varies. How it is varies? Suppose there is 126 candidate available in the list. The last UR candidate secured, suppose 190 marks. Then 190 marks will be the cutoff mark. Out of 126, suppose 10 candidates did not prefer to join. In this case, 5 candidates did not join.
Then there is a waiting list.
Then the cutoff mark will be
waiting list.
reduced. The cutoff mark will be reduced.
Sir, I do not know.
Eh.
But I know in a service, jurisprudence,
My lord,
it says that if there is a declared vacancy in a particular reason,
right,
then the list of the eligible candidates
my lord,
is published.
my lord,
Say, as you gave an example, 126 posts
my
of
lord,
the cutoff
My lord.
district
My lord.
is notified.
notified,
Then 126 candidates who are in the order of merit.
Merit.
From ascending to a descending order,
my lord,
then the candidate who comes in 126th position,
right,
that's top, and the marks which he obtained will be regarded as a cutoff.
cutoff marks, my lord,
Now,
right,
apart from that, the authorities also prepare a wait list.
My lord,
in contemplation or anticipation,
my
that
lord,
if any of these 126 candidates do not join,
my lord,
then these candidates who comes after 126,
my lord.
they may be accommodated there. So
My lord.
waitlist candidates must also be included there.
They have prepared a merit list of about 600 candidates. They have filed this, which is available on the record.
So
A merit list of about 600 candidates. They have prepared how much mark which candidate has secured. That is there.
Select list
I am-
with regard to 126 posts.
Yes, 126th post.
Yes.
Some candidates who have not joined, they have shown they have been appointed. My lord, they have filed the affidavit
No, we are
stating.
not on that point, sir. We are not on that point. You see, your mark is 192.002.
Right.
The earlier cutoff mark was 189.
Right.
0.588.
Right.
Then it is revised to 192.588.
Right.
So this revision, according to the opinion of the learned single judge, this revision done by the OPSC is not permissible.
Because of the fact, this is a development in the counter, not in the impugned order. Their lordship have taken note of to the Mahendra Singh Gill judgment. Their lordship have taken note of the judgment of Mahendra Singh Gill. In the impugned order, there is nothing that the cutoff mark is 192.22558.
Yes,
That has been, no, in the impugned, my lord, no, but that is my case, entire case is that. My lord, kindly have a glance to pick.
How the learned judge could come to this finding that
They made their statement in a counter affidavit. That part has been discussed in the judgment itself.
They
My
have
lord,
not
your
produced
lordship,
any document to that effect.
I beg pardon.
They did not produce any document to that effect.
They-
They the revised cutoff date, cutoff mark.
They have not produced anything, not even the expert committee report, only counter affidavit. Only in the counter affidavit, they have stated we have undertaken a revision, and as per the revision, this is the cutoff mark. My lord, kindly have a glance to page 95.
their initial stand was that they have not accepted the report of the expert committee. Later on, when you insist, they have taken into consideration the report of the expert committee and accepting it,
My lord,
and then revising the marks,
right.
which was projected before the court or which was revealed before the court. The court has taken note of that.
My
Why
lord.
not the court will take into account this impact?
My lord, before the honorable single judge, they have submitted two numbers. Now they have filed affidavit before this honorable court. There are 11 candidates who have secured much less mark than me, but they have been appointed. There are 11 candidates who have secured much less.
Something which goes in your favor, why you are taking an exception to it?
No, I am not, my lord, they are avoiding by virtue, my lord, by virtue of an interim order passed by this honorable court, 2 posts were kept vacant and 2 posts are lying vacant for these petitioners. Before the honorable single judge, thereafter the judgment has been passed. And they have not taken any, this honorable court has not passed any other order. And there is a direction to keep.
The pleadings are complete or?
Yes, ma'am.
Pleadings are
Yes,
complete. We want to bear out this matter finally.
Very well.
My lord.
If you are ready to argue finally today, then you argue finally today. If all of you are ready.
Next week, my lord.
But like next week, we need it. Yes.
Next week, your lord.
We are appealing for the intervention. We are the people who might be affected if the list is revised. We are appealing for the intervention.
The list has already been revised.
On the date when the list is revised now, and we are falling short. We were the last year. I was at serial number 122 before the list was revised.
But
Now I have been appointed. I was never made the party in the writ petition.
well, it's in all fairness to the respondent. There are persons who were in the original select list who have been appointed, but they do not secure the cutoff marks as per the new select list. They are also lower than the respondent in merit. However, because
Understand.
Yes,
they
ma'am.
say that now because of this, the right has already been accrue
My
to
lords,
them.
my lords,
Now, any decision taken would affect their right.
very well.
With the necessary parties.
My lord,
We,
before,
we are conscious that how to protect the interest of those who have already been joined. But equally, we cannot ignore if their right is infringed, then we have to do.
Your lordship is,
Yeah.
I bow down.
my lord, before their appointment letter was issued, a division bench of this honorable court
You are
passed an
concerned-
interim order.
You are concerned with your right.
Obliged.
If you are selected, when you are happy, you are not espousing the cause of the others.
No, not for the other. Obliged.
Be happy for that. Yes.
Means we must apologize because this entire litigation has arisen because of our mistakes.
That should be taken in lordship.
Yes.
No.
My lords,
That
we
the
apologize
6
for that.
Already has been passed from the date of the.
Provided any adverse order is passed against you, if we think that any adverse order is to be passed, we will definitely permit you to intervene.
We are under apprehension. That is.
Why did not approve the single judge?
Your lordship,
You were under apprehension.
because your lordship, before the list was revised, we were already selected. Let you be there. We will hear finally, when we will hear
The
finally.
secret bench, why you did not apply? Why when appeal you have come? What's your explanation?
Your lordship, there is a specific prayer to that effect that we should be removed also. There is no particular arrangement that.
Sir, are you not understanding what is
Yes,
possible?
sir.
Now you are coming before the appellate court in an appeal.
There's a.
There was a writ petition pending before the single bench for a pretty long time.
Your lordship.
Why you did not apply before the single bench for your addition?
What has happened, your lordship, on 13/3/2024, after the disposal of the original writ petition, a notification was published where we were placed at serial number 180. Where, your lordship, there is I have filed an IA where I have attached that particular notification.
Did you challenge?
No.
So,
No.
so
The court selection.
what right now you have approved? In order to be implemented, you have to say whether you are a necessary party or you are a proper party.
Only plea I
Whatever
can
you
take.
will take to,
Your lordship, the only plea I can take here, your lordship.
in case they would have approved the single bench when the writ petition was pending. That cannot be, we'll see to it later on. Have to find your IA,
Your lordship, IA 7412/2002.
consider it. Well, next week.
Next
you
week.
will
Any
handle
date.
the main matter.
My lord,
Any day. Any day, my lords.
Mr. Behra,
Thank you.
London Council for the appellant. And Mr. Samal for private opposite parties, as well as Mr.
Can you come on fifth? Because we have fixed many matters on 9th.
Yes. 15th.
Subject to my learned senior's convenience.
For the
15th.
starting this 15th
15th April.
of that week.
Mr. Samal for the private opposite parties and Mr. Das, London AG. List on the party list on 15th April as prayed by the parties to finally hear the matter. To hear the matter finally.
Item number 29.
I am a government servant. Two writ application disposed of in a common order. One writ application 6339 of 20 was allowed, and second writ application 317 of 20 was not allowed. Both the writ applications disposed by common judgment dated 16th July 24. But the crux of the
Maximum one.
matter already discussed prior to discuss in this honorable court,
One.
and one of the crux and the main point of the matter, honorable court earlier discussed the why 376.
It is the same petitioner came in two writ petitions.
Yes, Miller.
Same pit,
There are two disciplinary proceedings, so he challenged two proceedings.
two
One
discipline.
proceeding allowed was under.
Against one, it was quashed.
Yes.
Against other, it was dismissed, the same was remained.
Yes. The Honorable Court did not like to interfere in the decision on that proceeding because when the proceeding of the main, we have, though before this Honorable Bench for the first time, but Honorable Court earlier discussed things and the only question Honorable Court given to the government advocate, where was the scope, the FIR or the trial court, where he made committed, where has the scope to add 376, for which 2 black marks in his career has been given, like which is major punishment for no fault of his.
They are a police officer,
Yes, my lord, a sub-inspector.
sub-inspector.
Yes.
Discipline the organization.
Yes, my lord.
Slightest mistake. Because of grave
Like,
nature.
yes, my lord. But where the mistake? Where is the scope to add 370?
In allegation against you.
Yes, my lord. Main allegation that I have not added 376. That is the main allegation. What?
If there was an ingredient.
No,
If
no,
there
no.
were an ingredients.
Yes, my lord.
Which would justify the inclusion of section 376.
Yes,
like
ma'am.
we see.
Yes. My lord, on to, my lord, on.
Dereliction or misconduct, I do not know. There may be further reasons for not inclusion.
My lord, why that thing? The matter, a girl allowed with his, due to law, allowed with a boy on 22nd, 11th, 24. After 4 days, the mother came to the police station, lodged an FIR, without stating that doctor has been only stated doctor allowed with somebody else. Then told he is residing in the relations house of that boy, male member, belong to one village. And on 29th, after 3 days, the girl could be traced and sent to the medical report. And the doctors reported, Dr. Anita Hota reported no bodily injury on her person suggestive for foreseeable sexual intercourse. Second, her clothing had no physical clue to alleged sexual offense. 3, virginal swab collected. There was no sign of
What is the
symptom
charge?
of recent sexual.
Was she a minor or a major?
In fact, she is a major former as per her school certificate. But when the case was started, total minor.
What was her 164 statement or 161 statement?
My lord, in 161 statement, he told that due to earlier he has law of affairs, so that's why he got it.
What about 164?
One should never hear told about rape. Rather, in this, when he allowed a regular case going on the SDGM court, and in that court, that girl, during his cross-examination told, yeah, earlier also I, because of the law, earlier I used to go to.
Can we enter into such factual facts?
No, factual only, because there is no ground to enter 376. Where is the ground? That question Honorable Court put to the government about 3-4 hearing made Honorable Court earlier. Today I am partly at the beginning, the government advocate, they show us the Honorable Court where I will add 376. What is the scope? Neither in the FIR nor in the victim.
So what has been done? Then what was agreed, sir, if the learned judge has asked?
Because
him
2 black marks on imposition a major punishment on me, which borbats my career.
No, what has been found, the inquiry report suggests that there was a misconduct on your part.
They are telling,
Disciplinary authorities
yes,
must have been.
the government, they say what mistake committed, let the government say, but what I know.
I am not. Sir, so far as the Writ court or the appellate courts are concerned,
Yes.
they are not a court of appeal or
Right.
sitting over as an appellate jurisdiction
No.
of those
Yes.
authorities.
Yes.
That-
No, yes.
We will simply decide whether the process by which the decision has been arrived or the proceeding is conducted is fair.
Yes, madam.
We will only say, and the principle of natural justice has to be adhered to.
Yes, madam.
Tell us, we will not enter into the merit, whether there was a case, there was an immaterial on all these things. We will not go into that. You have gone.
Why?
We are not a fact finding authority.
No. Why I come to the shelter visit? I am severely prejudiced. When I have commitment, no mistake about this allegation, let government say, the government says, this is this one for which you have been. Honorable to earlier act, then the government council show they where I should add.
Number 74.
Yes.
Matter 18th March, because of the late submission of parameter adjournment given by this honorable court to the government advocate. On 18th March. Put up on 6th order again. State has preliminary adjournment to otherwise demonstrate from material in the record.
Yep.
It was
You
state,
see,
state to submit.
what is the disciplinary proceeding 9/13?
Yes, that is.
9/13.
Yes, Mira.
So the charge in Titlagot PS case number,
Yes, Mira.
it was registered for 147, 148, including 376.
Afterwards, 370, when I transferred from the police station, it was added after my transfer. Not when I was working as the.
So initially you did not register 376.
Because there was no scope, there is no affair, nothing else.
So where is the material to show that
Sir,
you had?
that is the
there
thing,
was-
honorable asking government, what the material show to add 376.
No, no.
Government of advocate has taken time for
No,
that.
no, you satisfy why the government advocate.
As-
You source.
Yes, yes. Affair does not whisper about anything rape. Victim has not stated. Mother came, told you after 4 days of the incident on by the daughter eloped.
Where is the statement of the victim?
Statement of the victim are there.
Where is it?
And in the, there was a trial also, but it has ended.
When you took the statement of a victim, tell us,
Minor, pardon.
what is the date when you took the statement of a victim?
Statement of Miller.
Victim.
I took it on 29th. I
On-
sent her to medical.
Where?
I medical report, all these things I sent on 29th.
I am asking you a statement of a victim under section 161 of the CRPC.
Victim was not there. Her mother came to me on 26th to file a FIR. My daughter not in the home. Eloped with somewhere. He was not traceable.
Sir, she was retrieved, she was rescued.
Yes.
You have sent her to medical examination.
Yes, ma'am.
29/6/2011.
Yes, ma'am.
I am asking a very simple question. When the statement of a victim, lady or a girl,
Yes.
was recorded by you under section 161. On 29th or 28th or 26th or 27th or a 30th or thereafter.
No, 29 medical, 26th mother affair. In between day, 26 to 25.
Go ahead.
26 the first affair, that 29 the medical I have sent.
Cases
to
are like this. Not as simple as you are projecting before us.
No, sir, 161 said not during that
Charges are
period.
very grave against you.
No, yes, sir. 26, if mother lost the affair. 29th,
Not disputing.
the doctor was.
Probably.
No, yes, I minor.
Remnant of my mind
I
is
understand.
not the
Minor is asking the date.
teaching
I'm
of
sorry.
the-
The minor is asking the date of the 161 statement.
My query is very simple, sir.
Yes, ma'am.
Please.
161
I
date.
have seen from the chart
One
that you took the victim girl for medical examination on 29/6.
Yes, ma'am.
My specific question is, when the statement of the victim girl recorded
Yes.
by you?
Take your time. I am-
Date, sir, please.
Only date. In Odia, I have translated to English.
I just wanted the dates.
Yes, date, I am finding you date. April. कौन सा नहीं जानी? So 26 and 12. In my 2 days copy. इधर कौन लिखा था date लिखने जानी? मेरा translated copy and Odia copy. Yes. मेरा second.
Come ready at 2 PM, sir.
No, 2nd January is.
Come ready at 2 PM.
2nd January 2016.
2000?
16.
161 statement.
Oh, sorry. Oh, sorry. Sorry, sorry. Sorry, it's a court order. Sorry.
Copyright,
No, no.
161 statement of a meeting.
I'm, yes.
Lordship.
Item 29.
Check.
Yes, I got it.
Yes.
My turn is 161, that meant on the same day, 29/6/2011.
Okay.
The day she sent to medical report. The page of that is in the page, only also in the file, running page 178 of writ appeal, the 161 statement. Prior to that, proceedings. In the lower court, in the lower court,
170.
178 running page. Internal page 119. In running page, writ appeal 178. And he has stated in that one, it is
178.
178
Not 278. 178.
running page. She has stated I had a relation with that law of affairs. And second, prior to.
No, this is not a statement.
Minor.
Oh, this is a statement. I do not know what. This is in our vernacular language.
Yes.
Is not properly.
Statement,
clear.
161 statements.
This is a clear copy also I have 161 statement. Both are having robbers and about to marry. He confessed also that regard. And also in the trial court, in cross-examination prior to one page before that is one.
Why we will go into those aspects of the matter?
No, true. I am impressing the truthness of the case. Truthness of the allegation.
That the accused kept physical relationship with her.
Then, without her consent,
No, he has said that physical relationship was kept.
was established.
Yes,
There was a
said in
physical relationship with the accused.
Yes.
Relation.
Have
Not
you
now,
said
prior to that.
without consent or
But-
forcing something.
But she is a minor, no?
No.
No, it's a major, or major.
No, sir.
What is it?
17 years.
Huh? Oh, then she's a minor.
No, when case
Sir,
is minor,
when
after
the
whom the SLC, when SLC come to the limelight,
Sir,
no,
when
that
the
is my
offense, when the offense is committed, is the, I would
No,
say with
major,
important
major.
date.
No, major, minor point.
No,
Date of-
he's
date of-
17 years, it
The date
says.
of birth, as per the SLC, school living certificate,
Listen, sir,
yes, sir.
when the age of
This matter along with that, any date next week,
list along with WA number
3344 of 2050.
3344 by 2024. On one
This matter. This matter.
one chapter.
I'm appearing for the respondent minutes. Respondent.
In item 30,
In item 30, I am for the respondent minutes.
but your name is not there.
No, I've just filed my appearance.
Mr. R. Tarafa. The respondent.
Not just fixing.
Item not.
Fixing a date
21st.
21st.
Item not 32.
32, Your Lordship. I'm sorry, I'm appearing on VC, Your Lordship.
Yes, madam.
Yes, Your Lordship, here I'm challenging the order under Annexure 2, wherein I have been service tax. Similar matters are pending, your lordship. If and counter has also not been filed.
I need some time to end the counter.
Who are you for?
I'm for revenue.
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 I am for the petitioner, your lordship.
With the standing counsel.
Yes, sir.
Your name?
Umesh Chandra Sahu.
Ms. J.D.M. Wallace for the petitioner and Mr. Umesh Chandra Sahu for the opposite parties. Time is sought for by Mr. Sahu to file his reply affidavit.
Yes.
List on in month of May.
22nd.
22nd. When you will file?
That's why I have not received from the department. I have intimated.
So put it in May.
5th May.
5th May.
Obliged.
Item 33.
Which for the petitioner? Non-appears. None appears on call for the petitioner. List on 8th May.
Item number 35.
May I please, Your Lordships? Your Lordships, in this matter, I have challenged the order in original where the order has been passed violating the charging section 73, section 73, subsection 4B of the Service Tax Act, Your Lordship. And where it is, it has been mandated that within 6 months or 1 year, the order, adjudication order has to be passed. But here in 2020, the notice has been issued and order has been passed in 2024.
And at the phase under section 4B is where it is possible to do so, my lord. If your lordship will come to the page 11 of the brief, my lord.
I have quoted the section in.
My lord,
at page-
sister has quoted the section itself.
Page
11.
11 of the read.
11. Four B, my lord. The central excise officer shall determine the amount of service tax due under subsection 2. A, within 6 months from the date of notice where it is possible to do so in respect of case falling under subsection 1. Subsection 1 is without applicability of the extended period of limitation, my lord. B, within 1 year from the date of notice where it is possible to do so in respect of case falling under the proviso of subsection 1 or the proviso of subsection 4. Here, admittedly, the notice was issued in the year 2020. And as your lordship knows, because of the COVID virus, and as for the decision, as for the show matter order of the Honorable Supreme Court also, any limitation has been extended up to 23 February 2023, my lord. So, in this case, I'll file detailed reply, my lord.
Mr. Ms. Chowdhury for the petitioner and Mr.
Chowdhury Satyajit Mishra, Senior Standing.
C.S. Mishra, Senior Standing Counsel for the opposite parties. Mr. Mishra seeks time to file his reply affidavit. List on 12th May.
Much obliged.
Yes.
Item number 37.
Pardon, Lordship, interim order to continue.
Interim order.
Yes, yes.
Interim order dated such and such shall continue.
Obliged.
37.
Mentioning in the first hour, madam. I was mentioning in the first hour.
Why?
Adjournment.
Both parties.
In this.
All right.
Satyasivadas.
List on. We'll adjourn it to June.
Well.
List in 30th June as prayed by both parties.
Yes, so item, your lordship, I am for the respondent. A copy notes of.
You are Mr. Barikna,
Satyasivadas.
Mr. S. Das for the
Appellant.
appellant and Mr. Monta for the respondent.
Item 38.
Matrimonial. Yes. ରହୁଛନ୍ତି ଭଲରେ
Sir.
Can it be short date plus urgency is there, my lord? In the unreserved land, construction work is going over Gochar land. So last occasion, state has filed counter, but the work is going on.
Somebody was here.
Yes, yes, I was held up in different court. Lordship may adjourn, short date may fix. Any short.
but
I will
state
inform.
has recorded the.
No, you have to bring him because he was present, he is present, the order is passed.
I will inform him, sir.
No, you bring
You
Mr.
have
Kar.
to bring him. Mention otherwise tomorrow.
Let it come on 8 May, why you?
This admission item number 1.
Who is appearing? Who is for the petitioner? Where is an agreement? Where is an agreement, sir? Containing an arbitration clause?
42.
Section 11 application,
My lordship at page 43.
page
43. At page 43, you also will find 8.2.1.
Lordship, 8.2, dispute shall be settled by arbitration in accordance with the following.
Is important.
just one. There is an application, the notice under section 21.
My lordship at page 161. 161.
Any reply? Because there was a clause for joint.
Placing that clause C of that page 43.
Yes,
Clause C, if
Yes.
in a dispute subject
within,
to.
I have seen that.
Yeah.
So there are mechanism which is provided.
Yes.
If there is any technical matter, then in that event, either of you can appoint one and the third. And that is what I wanted, whether all these procedures has been exhausted or not.
The lordship may grant me one time.
For what?
This instruction. What
Now, this dispute,
For me.
there are two things after the special bench judgment of the Supreme Court in SBP versus Patel Engineering. 2005 volume 8 SSC is now a judicial dispensation. Is no longer an administrative order. It's a judicial order.
Yeah.
So we have to say that this dispute arises from an agreement.
From
And the agreement is a valid agreement. and then you have failed to comply. So these are the three elements I have to go. So tell us, the dispute appears to be a non-payment arising out of an agreement.
The work has been.
And you have not replied, you have not appointed the arbitrator. He asked you.
That is why I prayed your lordship, if your lordship grants me 1 week time in this that period, if I am in a position to submit to your lordship about the developments.
Anyhow, he wants time. I do not know he will be able to justify because he has not communicated to you about his part under the agreement.
These documents appended to this writ application doesn't carry such.
Why a writ? It is not a writ.
This is, sorry, arbitration petition, sorry, I'm sorry. Ma'am. In this petition, such a document is not there as to whether we have replied or not.
No. The dispute was raised in connection with the agreement containing an arbitration clause. And was duly communicated to the respondent. Stop. The clause pertaining to the appointment of an arbitrator is vividly incorporated in paragraph 8.2 of the said agreement. Stop. The exhaustive mechanism relating to an appointment of an arbitrator has been agreed upon by the parties, and the invocation thereof appears to have been made by causing a letter dated 8 July 2023 by the petitioner. The counsel for the respondent submits that they may be given an opportunity to take an appropriate instructions on the steps having taken after the receipt of the said communication dated 8 July 2023. In such view of the matter, let this matter be listed Friday week. Next Friday I may not be available, so it's better Friday week.
Item number 2.
Item
My
one
lordship,
has got two bits, sir. Item number 1
There
has
are
got
two
two,
matters.
both are said.
Arising from a same agreement.
No,
Then
lordship,
different
different agreement, different work.
The clauses are one and the same.
My
8.2.
lordship, clause are
Clauses are-
same, but letter are different.
Letter dated
Letter is
Dated,
different.
my lordship,
That is 10th July 2023.
10 July. Yes.
Item 2.
This is an application under section 11(6) matter. The arbitration clause is at page 20, man. Page 20 of the lordship's brief. Clause 25.
Who is for the other side? Have you served the copy on the other side?
Yes, my lord.
We are appearing for the.
Union of India.
Oh,
Yes, I am the virtual.
yes, sir.
Yes, my lord.
What is your stand, sir?
It is a part of the agreement has been annexed, not complete agreement, number 1. Number 2, other any notice has been, after the notice, other any communication is made, that is not also disclosed. I'll take instruction, let me keep it updated. Even though there is a page 21, there is an arbitration clause, but alternative mechanism has been exhausted or not. There is a order was passed, which is
Page
annexed with the-
21. Page
Yes.
21.
My lord. It is a part of the contract, what they have annexed. Might have been the clause 25 or.
This is
because
the clause 25. The
Yes,
clause
it is
25 is. And where is a letter raising a dispute?
On annexure 7,
Page
page 44.
44.
44. Starts from page 44. 2/12/2024 letter. Starts from page 44.
So you want to take instruction?
Yes, my lord.
The counsel for the respondent prays accommodation to take a necessary instruction from his client. More particularly, any steps having taken in pursuance of the communication dated 2/12/2024, raising a dispute arising from an agreement entered into between the parties. List the matter.
Item 3. Minutes, may I please watch the notice. This application
Service.
11.6 read with section 14 and 15 of the Arbitration Act, my lords. My lords,
Yes.
here, my lords, is a peculiar case, my lords, wherein I've prayer before my lordships is that for appointment of substitute arbitrator, since the matter
Then
was.
why the mandate of the arbitrator is terminated or
No,
what?
no, my lords. The matter was before the state, one was the state arbitration tribunal. That has not been functioning since the last 15 years, my lords. That's why I've come up before my lords in section 14 and 15.
Then we'll have to show the service on the other side.
No, my lords, the notice, let the notice go, my lords, because the private party and also that it call, my lords.
So you'll have to put them on notice.
My lords, my lords.
Their appearance is necessary before us.
That's why I pray, my lords, let notice go to the parties and my lords, in his, my lords, coordinated this thing. My lords
Notice.
has already, yes, my lords.
Put in the requisites.
Yes, my lords.
Returnable on 25th.
Please, my lordships.
Item number 4.
Lord, the arbitration clause is 87 paid 105.
Other side.
Man, the notice has to go.
So serve a notice and come back on 25th.
I'll take file requisites for issue.
Please. Be
Grateful.
Requisites immediately.
Item 5.
May I please, my lords. On the arbitration clause, my lords, at page
64.
my lords. No.
Page
63.
No. Page 63, my lords. 63. No, 63, running page. 76, my lords.
Yes.
Sorry, my lords, 76. Page 76, 25(3). Arbitration one, GCC clause.
Just 1 minute.
My lords got it, 76.
76.
7.
Haven't tally.
Set up what's required.
76, please, tally on the.
76.
Where is the notice raising a dispute?
Notice.
So notice at page 121, my lords.
Show the service.
When this, after 121, my lords come to page 123. After that, my lords, come annexure 9, my lords, 123, where the Orissa State Disaster Management Authority, who is the principal employer, with reference to subject matter, I am to say that on behalf of your clients, as per the request mandate, Managing Director Osama, the following list of arbitrators have been.
No, they have already they finalized.
My lords, peculiar my lords. There, my lords, and page next the page annexure 10, page 126. I've given after that, I've given my consent also.
Then
after that, my lords, the recalled, particularly unilateral decision, they have recalled their order. Page. That is annexure 11, my lords, page 127. After mutually agreed, they have fixed the arbitrator from the arbitrator panel, fixed by the Honorable High Court, and I've agreed to it. Then at page 127, they recalled it unilaterally, my lords. That's why we again come up before, again I've written a letter to them. After that, I've again come up before my lordship of 11.
So they say that you have chosen 3.
Yes.
They wanted a single arbitrator,
Yes,
sole arbitrator.
Anyone. They have chosen, my lords. That is at the page 124. That is 37.
No,
Serial
no.
37.
120.
124.
124 is a list of the
Yes,
panel
my lord.
arbitrator.
Yes,
So you have agreed for that.
Yes, yes,
Then
yes.
they backed out.
yes, my lord.
And they say that
Yes.
please choose only one arbitrator.
No, my lord, they have,
Where is this?
they have selected one arbitrator only. My lord, against that, my lord, that is
No. As per the rule 9, sub-rule 3 and 4 of the internal management rules, the
Well-
entire panel of the arbitrator is supposed to be maintained by the arbitration center of the Odisha High Court.
Well-
Should have been placed with this office to nominate one out of them.
Yes, my lord.
So as to agree on a mutually agreed sole arbiter.
My lord, exactly.
It appears that the entire panel was not placed to this office.
No, my lord.
There has been a violation of this. There is no joint memorandum signed.
Huh.
And in view of the avoid future,
No.
earlier nomination is recalled.
Exactly, my
So
lord.
I understand that now they are not agreeing.
What is, they agree, that is positive. Annexure 9, my lords, they clearly say, then with reference to the subject cited above, and to say that on behalf of your clients, contractors, agencies, as per your request made to the managing director, Rosnama, by letter number such and such, the following list of arbitrators have been
Sir.
finalized, basing on mutual consent from the list of arbitrators published by the coordinator. They have written, my lords, to us. All these works, different works, they have finalized the names of the arbitrators, and which this is one with the 37, but pertains to this application of mine, my lords, where they have chosen only one, and I agree to it.
Where they have chosen one?
Yeah, there's 37, my lords, page 124, my lords. Page,
I do not find, I do not know. These are the list.
yeah,
Which one is yours?
Mine is at serial 37, my lords.
Serial number?
37.
This is the RP construction.
RP Constructions.
So Miss Dipali Mahapatra was the senior advocate who was chosen.
They selected, I agreed,
Okay.
my lords.
Then where is the difficulty?
That's what, my lords, that's what exactly.
So why the arbitrator? Then why you have approached us?
Because they recalled that order unilaterally without informing and nothing. After agreeing to everything, I will agree to their
Then they are not agreeing on the arbitrator.
No, they have suggested, my lords. I
understood.
My lords.
They have resigned from their earlier standing.
My lords.
I understood
My lords.
that both of you agree for this.
Yes.
Then they reside unilaterally. Now,
Yes.
if they reside, then somebody else to be appointed.
Yes, I don't
This is
mind.
what-
I don't mind much.
Yes.
I don't mind. Absolutely.
By the next date, your lordship will be sitting next Friday, so.
What?
I'll.
Name.
Your
Yes, sir.
lordship.
Any name, my lords.
Name.
I don't,
From the panel.
on the panel. Any name.
What is the total claim?
Claim is not much, my lords, around 25 lakhs. 25 to 30 lakhs maximum, my lords. I have 3 similar matters like this. So,
Can a retired judge of this court be appointed?
Why not?
that will be too less amount.
One.
Now, if the schedule is given,
Yes, my lords.
In that list
as
also,
per the schedule,
in that list also, Honorable Justice Dr. D.P. Chaudhary's name is there in that list.
Yeah, everybody's name is there. I don't mind.
At serial number 21.
what is your difficulty with this arbitrator? Why you
They have
recalled
selected,
it?
man. I didn't.
That I do not know. I have to type instruction as to why they selected then deferred. Deferred.
That is what I am really surprised
That
with that.
instruction, unless I have, I cannot submit to your lordship.
Take an instruction,
Well,
otherwise we will
Yes,
say
next
so.
week,
next week,
that will be
next
better. man.
Next.
The
On
respondent
20
is directed to take necessary instruction with regard to the withdrawal of the nomination of a learned advocate after having agreed initially. List the matter on 25th.
25th, madam. The next matter
26.
must same, my lord. Similar, same stand, same. Exactly same, my lords.
Same stand.
Same.
Yes.
Exactly same stand.
Same order.
Item 7.
Pleasure, lordship. I am appearing for the petitioner in item number 7, my lord.
Who is appearing?
This is the matter, first matter. Notice has yet to issue, my lord.
Notice. 25th. File the requisite, sir.
And
Item number 8.
It also, my lord, is exactly same, my lord, they have decided. Same as 4 and 5, my lords.
They have also decided.
My lords, they've decided, again, they've recorded.
Yes,
All
same.
Item 9.
obliged.
Who is appealing for the? Yes.
11 application is a fresh application, my lord. Notice is to be issued, my lord.
Fresh application?
Fresh.
Service?
Yes.
Is the same company which is the old company. Lot of judgments, constitution based judgments are there in your
This
name.
This GDCL, my lord, Gannon Dunkel is a very old company, my lord.
That is what I'm saying. There are a
Yes,
lot
ma'am.
of constitutional based decision
Absolutely, my lord. Yes,
relating to a work contract, relating to an amendment in the constitution, 42nd.
Right, my lord. So this is the GDCL, more than 100-year-old company, my lord.
Yes.
Gannon Dunkel, my lord. Yep, yep.
Well,
Item 10.
Please, my lord. This is also a press, my lord. I'm challenged the
Service. Service?
service, my lord.
Item 11. 11.
May I please, your lords?
Fresh?
Fresh one.
Service?
12 is just the same.
25th. Come.
Yes, ma'am. Item 12.
12 is same, lord.
Yes.
Item 13.
13 I have to put service.
Yes. 25th.
Item 14.
This matter, notice has to go.
Yes, service.
Item 15.
It is also a fresh matter, but the copy has served to the central government. my lord.
I'm
Central government-
appearing. I also take instruction on.
Take instruction. Take instruction.
Yes, madam.
Give your memo of appearance.
Yes.